Allez-y, entrez, puis c'est...
Everybody's present and accounted for. Shane, you got one of these? New folks.
for what? I'm gonna turn it off. So I think it was replaced. So. All right, good morning, councils, interested parties. We're back on the record in the matter of the state of Georgia versus Khalif Adams et al. In 22 SC 183572. I'm going to go ahead and take roll at this point in time. Mr. Stillwell, Mr. Bunce, and Mr. Sharp. Good morning, gentlemen. All right, Mr. Williams, Mr. Adams, Mr. Steele, and Ms. Renard. Good morning. Mr. Kendrick and Mr. Weinstein, good morning. All right, Mr. Matthews, Jr. and Senior, Mr. Huey, good morning. Mr. Nichols, Mr. Westmoreland, Miss Westmoreland, I should say, Mr. Harvey, I'm glad to see you back, sir. And is Mr. Garner with you today? No? Not today. Okay, all right. And then Mr. Ryan and Misty Williams. Good morning. Okay, all right. Okay, Ms. Hilton and Mr. Brown and Mr. Smith, good morning. Good morning. All right. Before I get started and take up all our jurors here, Sergeant Ingram?
Yes, sir.
Okay. Is there anybody here from Law&Crime? Can I get you to come up here along with a representative from the state and maybe one person from the defense, please? Yeah, I need to take this in. All right, it's talk radio. Can you all hear me? Listening devices, everybody, please. All right, can you hear me? Somebody give me a thumbs up? Okay, all right, thank you.
Okay, come to the bench. Go on this side, on the other side of the TV. Thank you.
All right, before I call in our jurors, anything I need to take up with you before I call them? Okay, if not, Sergeant Ingram, if you'll summon our jury for us, please.
I believe Ms. Hilton is on top of it, but for the mall security officer, it's an event 7/7/2015, that's July 7, 2015. I need to interview those people, but I think Ms. Hilton is on top of that. And then I have a motion about character. That's it. Very brief, I just wanted to let you.
Now?
You can do it now, we can do it anytime you want, but if you stop, I don't need that now. Just
Okay, all right. Okay, all right. Summon our jurors, please. You need to let me know before the witness, okay?
Yes, sir. Thank you.
All right, ladies and gentlemen, please be seated. All right, thank you, Sergeant Ingram. All right, ladies and gentlemen, jury, good morning. Good morning. Finally, okay, all right, so, all right, ladies and gentlemen, at this point in time, we're going to continue with the presentation of the state's case. So at this point in time, Ms. Hilton, call your next witness.
Thank you, Your Honor. The state calls Sergeant Cornelius to the stand.
All right, summon Sergeant Cornelius, please. Sergeant Cornelius, good morning, sir. Sir, if you would please approach the witness stand. Once you get there, if you'd be so kind to turn and face Sergeant Ingram, who is sworn as a witness before you sit down.
Raise your right hand. You swear affirm testimony you give today the truth, whole truth, nothing but the truth?
I do.
Have a seat.
Thank you.
State and spell your first and last name for the court.
Jonathan Cornelius. Jonathan, Jonathan. Last name Cornelius, Cornelius.
And good morning, sir. How are you?
Good. How are you?
Where are you employed?
With the city of South Fulton.
And what did you for the city of South Fulton?
I supervise the narcotics and gangs unit.
Okay. And how long have you been with the city of South Fulton?
3 years.
Prior to your appointment with the city of South Fulton, where did you work?
I was employed by the city of Atlanta for 15 years.
And what did you do for the city of Atlanta?
Canine handler.
Okay. And were you a canine handler for the entire time you were with the city of Atlanta?
No, ma'am.
Okay. Tell the jury a little bit about your history with the city of Atlanta.
I started out in Zone 4, Allison Court, Dover Drive, all that area. I was assigned to Red Dog for about 3 years. Then I was assigned to Apex for about 3 years. And then my last 5 years, I was assigned to K9.
Okay. And when you said you're assigned to K9, tell the jury a little bit about what you do as a canine officer.
We respond to any type of canine calls, whether it's narcotics related, whether it's a missing person to track for a missing child or something like that. Self-initiated calls, just out driving in the higher crime areas. We're tasked out to assist the DEA, ATF, outside agencies with calls when they didn't have a canine available.
Okay. And you're talking about him. You have a partner within the K9.
Yes.
And who's your partner?
Shakona.
And Shakona dog.
Yes.
Okay. And
He thinks he's a person, but he's a dog. Yes. CHAKON.
And does Shakona have to go through any training in order to assist you and serve as a K9?
Yes.
Your K9. What type of training does Shakona?
So initially, you go through the process of picking out a canine that would best work for what we need. So it would have been tracking narcotics and article, which is like evidence recovery, anything with human odor on it they can find. And then the initial is a 12-week training program where they go through, you imprint the dogs on the odors that you want them to be trained on to find. And then after that, you certify the dog with a nationally recognized certifying official.
And how often does your canine have to get certified?
Every year.
And do you still work with Shakona now?
I retired him about 3 months ago. So he's probably at home watching this on TV.
Okay. I want to direct your attention to 2018. Was Shakona up on all of his certifications in 2018?
Yes, ma'am.
And I want to direct your attention specifically to October 23rd, 2018. Did you have the occasion to assist Officer C. Ross with an investigation?
I did.
Basis.
Your Honor, 403.
Overruled.
Okay. And how did you assist with that investigation?
He notified me by radio that they needed an open air search done at 2612 Steele Avenue. Once I received the call, I don't recall exactly where I was at that time, but I went directly to that call to assist Officer Ross.
Okay. And as we just discussed earlier, you said that it was Shakona, your dog that was with you.
Yes, ma'am.
And was he certified during that time?
Yes, ma'am.
All right. Let's show
You may.
I'm going to show you what's been marked as 75 and 76I. Tell me if you recognize 75 and 76I.
I do.
And how do you recognize 75?
These are Shakona's certifications each year through the NNDDA.
And what is NNDDA?
National Narcotic Dog Detector Association.
Okay. And is that the certifying agency that certifies all K-9s?
Yes.
Okay. And is
Well-
that, go ahead.
There's a couple of certifying officials we utilize in the DDA. But there are other ones out there, but this is one of the nation's top ones, which is why we use them.
And does that appear to be a fair, accurate depiction of Chacon certifications for the years of 2016, 2017, 2018, and 2019?
Yes, ma'am.
Overruled.
You're right, this time say like the Senator States exhibits 75 and 76 into evidence.
Aye.
Yes, 75 and 76 aye.
Any objection, madam? All right, so noted. They're admitted.
Commissioner Pelley.
Yes. May function as you see fit.
Thank you. Now, first looking at 75I, and we want to specifically just go to kind of 2018, which was May 24th, 2018. Just walk the jurors through what he has to get certified in. We talk about temperament, building search, criminal apprehension. Just walk us through that.
Okay, so the first three, you'll see that there's a line through those. Those are for apprehension dogs, which Chacon is not. If you see the fourth line, evidence recovered, he would have to find 3 items of that are placed out by the certifying official. It's done blindly to me and Chacon. So they would set the items out. They would give it a rest period and then tell me a certain area to go search. He would have to find all 3 of those items within, I believe it's a 2-minute time frame. You'll see agility and obedience are marked out because that also falls under apprehension dogs. And then tracking, you'll see that that's self-explanatory. They lay a track for us. They might give it 30 minutes to an hour, and you have to successfully find the person or toy or object at the end of that track, going over multiple surfaces from grass, gravel, dirt, multiple surfaces. And then area search and all that, the rest of it, that one falls under apprehension. Yes, ma'am.
And so for Chacon's purposes, he passed the test in order to go out and be able to continuously.
I sustain this form.
In 2018, was he able to pass the test?
Yes.
Did he pass the test?
Yes.
All right. And was he then able to continue assisting you out on the street? Objection.
I'll let you rephrase. I'll sustain the question.
After this, did he assist you?
Yes, Chacon met all the standards laid out by the NDDA and the Department of Atlanta.
Okay. And now let's look at 76I, particularly again focusing on May of 2018. If you can just walk us through May 2018 and the significance of what was passed for the certification in May of 2018.
Yes, so you'll see the 4 major narcotics up there, which is marijuana, cocaine, heroin, and methamphetamine. The others, we don't train on. Like it would be something like specialty, like fentanyl or something like that. So this encompasses all the major narcotics. So under methamphetamine, you would also have MDMA. Even though they're different narcotics, they still have the same makeup. So, but Chacon passed all of those, and these are also blind hides where they'll have, it might be a building or an office building or something like that. They'll hide the trained narcotics that are given to them by the DEA. They'll hide them blindly to me and my dog. they'll give it a cook time or a settle time, and then they'll tell me which rooms to go search. And Chacon has to find all those odors in different rooms within 6 minutes, I believe.
And was he able to successfully do that?
Yes, ma'am.
All right. So as of May 2018, he was certified for that aid.
Yes, ma'am.
All right. Now taking you, thank you so much. Now taking you to October 23rd, 2018, tell the jury what occurred, what you got on the scene in Chicago.
So when I get on scene, I talk to Officer Ross. He gives me kind of a background of what's going on, so I know what I need to do. After I get kind of the rundown of what they have out there on scene, I'll do a quick walk around, make sure there's no broken glass, any objects on the ground that'll injure my dog. In this particular incident, he asked for an open air search.
What is the open air search?
Open air is also named free air sniff. So you're just walking the dog around in the area to see if he picks up on any odors and then alerts to any odors or anything like that.
Okay. And did you begin conducting the open air search?
I did.
Okay. And what happened as you began the open air search?
So it was set up in a parking lot. I kind of did a loop around to the area where they wanted me to search. I always want to search other areas as I'm going through to just show that he's not just alerting on everything. And then once we got around to the area where they had several people detained and moved off, he pulled me to I believe it was a gray Chevy Sonic. Once he got to the Chevy Sonic, I noticed that his breathing calmed down, he slowed down, his tail starts wagging. When Chacon begins to get an odor, he gets excited, his tail starts wagging, and then you can physically hear him taking in a deep breath through his nose. And then at that point, he begins to bite at the door handle and the driver's side door handle and seam area, which is his natural alert, not taught alert. That's just something he does when he gets in on a trained odor, and then he begins to scratch at the area where he smells the odor coming from, and which is his taught alert to the presence of the odor of narcotics or controlled substances.
And then once he alerts, what happens?
At that point, I give him his toy. That's all he cares about. That's why he works. He gets his toy. I walk him around a little more to let him use the restroom, and I put him back up. I notified Officer Ross that I had a positive alert on the vehicle, and he took the case over from there.
And then as in this case, when Chacon was able to find an odor or identify an odor, and once you finish with that, does that usually conclude your involvement in the case?
Yes, typically if I don't have anything else going on, I'll I'll stay on scene with them just in case they need any assistance. But as far as handling the case, everything's on the officer at that point.
Okay. And did that conclude your involvement in this case?
Yes, ma'am.
I know that.
Cross. All right.
I just have one question.
I can ask you, go ahead. Go ahead.
Yes. Good morning, how are you?
I'm doing well, thank you. You indicated that you walked Chacon around the area generally, correct? Mm-hmm. Chacon didn't hit on a blunt that was on the ground near a white car, did it?
No, he did not.
Okay, that's all I have, thank you.
Anybody else? Any redirect?
No.
All right. May we permanently or temporarily excuse Sergeant Cornelius, I should say.
Permanently.
All right, Sergeant Cornelius, thank you for your patience with us. I'm going to go ahead and permanently excuse you as a witness. Please don't discuss your testimony with anybody except the attorneys in this case, okay?
Yes, sir.
All right, thank you, sir. All right. Ms. Hilton, call your next witness.
Thank you, Your Honor. Today called Joshua Masonzak.
What's his name? Masonback?
Masonzak, M-A-C-E.
Masonzak. Joshua Masonzak? Okay, all right. All right, Mr. Masonzak, good morning, sir. If you would please approach the witness stand. Once you get there, if you would turn and face Sergeant Ingram to be sworn as a witness before you sit down.
Raise your right hand. You swear firm testimony you give today the truth, the whole truth, nothing but the truth.
Yes, sir.
Have a seat. State spell the first and last name for the court.
Morning. My name is Josh Mackenzack. First name Josh, last name Macenczak.
And where are you employed?
I'm currently employed in the Department of the Army as a forensic examiner.
And how long have you been with the Department of the Army?
5 years.
Prior to working with the Department of the Army, where did you work?
I worked at the Georgia Bureau of Investigation.
And how long were you with the Georgia Bureau of Investigation?
Just shy of 14 years.
And what did you do for the Georgia Bureau of Investigation?
I was a forensic examiner that analyzed evidence for the presence or absence of controlled substances.
And tell us a little bit about your training education experience.
I went to Georgia Southern University where I received my bachelor's degree in chemistry. This was one of the main requirements needed to get hired by the Bureau. Once I was hired at the Bureau, I went through their training program where I was introduced to a variety of different substances that I might see, how to analyze those substances, and how to use the many different analytical techniques that were provided to complete my analysis. I was also trained in courtroom testimony for instances such as today.
And when you were with the GBI, did you have any continuing training at the GBI?
Yes, every year we were given a proficiency test which we had to analyze to prove that we were technically competent in order to do our job. We also were required to do continuing education through read-ins and meet-ins and just general journal reviews so that we can keep abreast of the new and exciting developments that are happening in the drug world.
And have you ever had the occasion to testify in court as an expert in forensic chemistry?
Yes, I have.
And if you know, about how many times?
Definitely over 100, but I don't know the exact number.
And have you ever been testified or qualified as an expert in forensic chemistry or forensic chemistry?
Yes, I have.
Your Honor, at this time, the state would like to tender Mr. Joshua Masonzak as an expert in forensic chemistry.
Anybody wish to die, Mr. Mackenzack? Okay, all right, hearing none, the court will designate Mr. Mackenzack as an expert in the area of forensic chemistry.
Thank you so much. Very briefly, if you can tell the jury, what is forensic chemistry?
Forensic chemistry is analyzing evidence that may be related to a crime scientifically for whatever the result of the submitter is looking for, whether that be fingerprint, drug analysis, firearms, DNA.
And while you were with the GBI, what specific substances did you test as a forensic chemist?
During my year at GBI, I would test substances that were positive for cocaine, methamphetamine, heroin, MDMA, spice, bath salts, any kind of pharmaceutical tablet that might be issued by a doctor.
I want to direct your attention to 2017. Were you employed with the GBI?
Yes, I was.
Okay. And I will take you to DOFS case number 2017-1020399. Were you given any items to test regarding that case number?
If I had a report to see, I could.
We're looking at a copy of your report. Have a refresh your memory?
Yes, ma'am.
Permission to approve, Your Honor. I'm going to show you what's been marked as State's Exhibit 87I. Tell me if you recognize Exhibit 87I.
I do recognize this.
And how do you recognize Exhibit 87I?
This is a very standard template. Sorry, my apologies. This is a very standard template that we would, for our reports, would look like. One of the main ways I can recognize it is on the second page. It has my signature along with my information, email, phone number, and my name typed out.
And does that appear to be a fair and accurate depiction of your report involving DOFS case number 2017-1020399?
Yes, it does.
And would looking at a copy help you today in your testimony?
One more time?
We're looking at how the report helped you today in your testimony.
Yes.
Your Honor, this time it stated like the tender states exhibit 87I into evidence for the purposes of this hearing. No, not to go back to.
Any objection to states 87I? All right, states 87I is admitted.
Now, taking you to the DOFS case number, were you given items to test in that case?
Yes, I was.
And who were the items given? What agency submitted those items?
According to this report, the Atlanta Police Department.
And I'm going to show you what's already been admitted. As states exhibit 61H and 63H. Tell me if you recognize exhibit 61H and 63H.
They do seem somewhat familiar.
Okay, and why are you saying you see somewhat?
Well, as I don't have my notes for me from the GBI and the photos that were taken, it's hard for me to do a comparison to what I see here versus what I saw at the time I opened this. However, there are some things in here that are familiar. This is a very standard evidence bag we received from the Atlanta Police Department. It does have the case number. When I flip it over, I see the items inside that match the description that I put on my report. And at the bottom of this one particular bag, I can see my initials I made when I sealed up the evidence after I made entry into the bag.
And would that have been your typical protocol to seal up the evidence and sign it when you finish testing the items?
Yes, it is.
And have you seen that bag with your signature earlier today?
No, I haven't.
Did my investigator show you?
Oh, yes, I
earlier
apologize. Sorry,
today?
I misspoke. Yes, I did see this 1B exhibit 63H earlier today.
Okay. And looking at both of these, does it have the DOFS case number as assigned on to the report?
Yes, they do.
Okay. And does it appear to be the same DOFS case number on your report as it is on those items?
Yes, the case numbers do match each other.
Okay. Now, when you were asked to test those items, what items did you receive?
I received a bag of tablets. There were two different logo imprints on.
He needs to see this report, but he's reading the report while testifying.
So is your objection to foundation?
Yes.
All right, I'll sustain this to that.
Your Honor, report is in evidence right now, so he could read from it. I'm sorry, I couldn't hear. The report is
Report's in evidence, so you can read from it, so I'll overrule the objection.
What did you receive?
I received a bag with tablets. There were two different types of tablets based on their color and the pharmaceutical imprint that were on them. There was another sealed package that contained 3 different bags. All 3 of those bags contained solid material. And then there was one bag that contained a single blue tablet.
And when you received those items, did you test everything?
No, I did not.
Tell the jury, why did you test all the items that you received? Did you receive?
There was the protocol of the GBI at the time because of the sheer amount of cases that we would get in. We could not test every single exhibit. The more exhibits we tested, the longer it would take to get through a case, and therefore our backlog would increase. So the procedure at the time was to look for certain things that would go through quicker. One of those being, is there a certain weight that we can target it more than the others? There's also the potential of, does this particular item possibly fall on a higher schedule than another one? These are all procedures laid out at the GBI at the time, and this is what I use based on my experience also to determine which item would be more preferred over the others.
Okay. And looking in this case specifically, which item did you end up testing?
I tested 1B.01, a bag of solid material.
And what was your reason for testing that particular weight?
At the time when I weighed this particular bag, it had a net weight greater than 28 grams. It is my understanding as a civilian.
Your Honor, he's an expert.
I'll overrule the objection.
Your Honor,
Can I just make this a continuing objection, madam? All right, I'll make a continuing objection.
It was a protocol of the GBI that anything over a certain weight amount should be tested first for the potential of Well, it was just potential of the protocol of the GBI. This one bag was over that weight, which was 28 grams, so it was the first thing I analyzed. Once I completed my analysis, I discovered it was a compound that was deemed to be the highest level that we could go, so therefore the other items were not beneficial for testing at that time.
So when you tested item 1B, I'm going to approach again. Looking at State's Exhibit 63H, do you see your initials on on any of those items in there for the items that you tested?
Yes, I do.
Okay. And which item did you test?
It was this bag right here, the largest one. Yes, ma'am.
And when you tested this one compound, what were your results?
You want to read my entire results or just a simple version? So it is a very long chemical name, but the substance that I analyzed is commonly referred to on the street as bath salts.
And what was the total weight of what you tested?
The total weight of the material inside the bag, so not including the bag, just inside, was 31.435 grams.
And again, why did you test on that particular bag?
Because again,
Overruled.
because at the time, the weight, the 31, was over the 28 that was in the GBI protocol, and that the particular compound that I identified justified that the other exhibits did not need to be tested.
All right. Now, as it relates to the other items that were given to the GBI to be tested, while you did not test them, did you identify in any way what the tablets could be based on?
Objection, speculation.
I'll sustain this to form. You can rephrase, madam.
Did you identify those tablets?
No, I did not.
What, if anything, did you do with the tablets once you obtained them into evidence?
So with the two different tablets that actually had a logo imprint, I was able to just do a quick Google search for what they could potentially be. And
I'll rule the objection.
what they could potentially be. Now granted, this is not identification, this is just an indication, but there was an...
Objection, Your Honor.
Overruled.
It's not identification, it's speculation.
Overruled. And I'll note your objection, madam.
At best, I was able to just at least indicate that it might...
Your Honor, I'm going to object. It's not in his report.
I'll overrule the objection.
It was an indication that it might be alprazolam, but I never did any chemical testing to verify that at all.
And the imprint on the pills, is that what you used? The imprint on the pill itself?
Objection form.
Overruled.
That is correct.
All right. After doing your testing on item 1B, did you produce this report?
Yes, I did.
And again, was it the protocol not to continue testing after you determine a certain amount?
Objection as to his.
I'll sustain that.
All right, I have no further questions.
Cross. Go ahead. Whenever you're ready.
Good morning.
Morning.
Will you pronounce your name for me one more time because I do not want to butcher it?
Mackenzack.
Mackenzack. All right, Mr. Mackenzack. You received the items to test in this case from Officer Chisholm, correct?
I didn't receive it specifically from him. I received it from a GBI personnel in the evidence room.
Okay. On your report, does it indicate received Officer Chisholm?
Yes, his name is on the report as the officer requesting the results.
Okay. All right, so you did not deal with Officer Chisholm directly, correct?
No, I did not.
All right, and you did not deal with Sergeant Maldonado?
No, I did not.
You do not, it would be fair for me to say that you do not know how the items you received to be tested was given from one officer to the next.
That is correct. I have no witness of how the evidence was handled before it entered the GBI.
Okay. All right, so if Officer Maldonado gave it to Officer Chisholm to give to the GBI, you don't have any knowledge of that?
I'm not even sure if that's how the order went either.
Okay, thank you. All right, and you can't tell myself and the jury what manner the items were seized, like whether it was in a container or anything like that. You just know how it was delivered to you, correct?
That is correct. I have no knowledge of how these items were seized.
Okay, so when the items if items were seized in a pill bottle, that's not how you received it.
That is correct. There was no pill bottle here.
Okay, so you didn't receive a pill bottle at all?
No, ma'am.
Okay. Well, let me ask you this. Let's talk about what you did receive then.
Okay.
All right. You received one bag with a few tablets, correct?
That is correct.
All right. And you received another bag with one tablet.
That is correct.
Okay, so we're at 2 bags?
Yes, ma'am.
All right. And then you received 3 bags with a solid substance.
That is correct.
Okay. So total, it was 5 bags.
Yes, ma'am.
And you're sure?
Yes, ma'am.
Okay. All right, so let's go over each bag one at a time, okay?
Okay.
All right. First, the bag with a few tablets. You received it in a sealed bag, correct?
That is correct.
Okay. All right, and you did not test that bag?
That is correct. I did perform no chemical analysis whatsoever.
Okay. All right, and then let's go to bag 2.
Okay.
Okay. All right, so bag 2, 1 tablet, correct?
Yes.
Okay, and you didn't test that?
That is correct.
All right. All right, so we're down to the last 3 bags, right?
Yes, ma'am.
Okay. And I just want to make sure, because I want to get it right. In those 3 bags, there was solid substance in each bag, correct? Okay. So when the arresting officer in this case stated that he seized 2 bags with substance, you received an extra bag?
All I can say is that when I opened the seal package, I received 3 different bags.
Okay.
I'm not aware of what the officer seized at the time.
Okay. So if the officer stated that he seized only 2 bags with substance in them, you received 3 bags?
That is correct.
Okay. Okay. And out of the 3 bags that you received, you only tested 1?
That is correct.
Okay. So you have 3 bags, 1, I'm saying extra, and you only tested 1?
That is correct.
Okay. Now, let me ask you this. You explained the GBI protocol to us in testing, correct?
Yes, ma'am.
All right. So if a prosecuting attorney called you and asked you to test those pills, you most certainly would have done so, correct?
Absolutely.
And you did not receive a call to test those pills, correct?
I did not know.
Okay. Now, the 1 bag that you did test, that bag turned out to be bath salts,
That is correct.
not MDMA.
Not MDMA.
Okay. All right, and that was the extent of your involvement in this case, was testing the one bag?
Yes, ma'am.
All right, let me ask you. You have no idea who that one bag of bath salts belonged to?
No idea whatsoever.
I have no further questions. Thank you.
Well,
Any further examination? All right, any further redirect, madam?
Yes, Your Honor.
All right, go right ahead.
In your experience as a forensic chemist, does MDMA come in a, can MDMA come in a powder?
it can.
Objection, irrelevant. There's no MDMA in this case.
Overruled.
Can it come in a powder form as well?
Yes, it can.
And are there times where items may come in labeled one thing, but once you test it, you identify it as something else?
What do you mean by labeled?
On this, what was marked on here? What's marked on here?
It says 2 clear sandwich bags of MDMA.
Okay. In your experience in working with GBI, are there times where items could be mislabeled or it's not MDMA when you test it, you find it's another substance or something else?
Overruled.
Yes, that can happen.
Okay. And in this case, let me ask you, bath salts, what schedule were bath salts?
To my best understanding of the law, it's a Schedule I substance.
Is that what you put on your report?
Yes, it is.
I'll strike the issue of his understanding of the law. If you can ask him a question in regards to that, but I'll instruct the jury on what the law is.
What did you know the bath salts to be in this case? What level, what schedule did you schedule?
Per GBI protocol, I was required to list Schedule I on the report.
And are you aware of what MDMA, what schedule MDMA is? Are you aware?
Again, just to my best interpretation of the Georgia Code, it's a Schedule I.
So both MDMA and bath salts are both schedule I, are
Again, to my best interpretation of the law.
Objection, Your Honor.
I sustain the objection. Ladies and gentlemen, disregard the witness's last statements about Schedule I. If it's applicable, I will charge you as to that.
Yeah, I'm going to ask for an interpretation, but
Objection.
Don't speak your objection, madam. If you have another way of phrasing this, please go ahead and do so. But he cannot testify about what the law is, okay?
But again, based on your report, that's what you noted, that the item that you substituted, the bath salts.
Objection, absent answer.
I sustain the objection.
I have no further questions.
Anything further?
Your Honor, just briefly.
Sir, at the end of the day, what you tested was not MDMA, correct?
That is correct.
Okay. And you did not test the pills, correct?
That is correct.
You cannot tell this jury with certainty what was in anything you received beside what you tested,
That is correct.
which was just bath salts.
Yes, ma'am.
Have a nice day. No further questions.
All right. Anything further? All right. Anything further redirect, madam? No. May we excuse Mr. Mackenzack permanently or temporarily as a witness?
He's permanent.
All right. Mr. Mackenzack, I'm going to go ahead and permanently excuse you as a witness. Please don't discuss your testimony to anybody except the attorneys in this case, and we appreciate your patience with us, okay?
Thank you.
All right. Thank you, sir. Ms. Hilton, what's the length of your next witness, just give or take, guesstimation?
Probably about 20 minutes.
Ladies and gentlemen, you want to go another 20 minutes, and then after this witness, we go to lunch? Or do you want to have lunch right now? Continue? Okay, all right. Call your next witness, madam.
Thank you, Mike. We're going to call Officer Stansel to the stand.
All right, summon Officer Stansel, please.
Do you swear affirm and testify that you are reporting the truth, the whole truth, nothing but the truth, and nothing?
I do.
You may be seated. Can you state your first and last name and spelling them both, please?
Sherrod Stansel, SHERROD, Stansel, STANCIL.
And where are you employed?
The City of Atlanta Police Department,
And how long have you been with the City of Atlanta Police Department?
7.5 years.
And what is your current assignment?
Currently assigned to the homicide unit,
And how long have you been with the homicide unit?
5 months.
Prior to your assignment with the homicide unit, where were you assigned?
I had a short stint with our robbery unit, and then I was with our general investigations unit, and prior to that, I was on Apex.
When were you with Apex?
From September of 2019 to December of 2022.
And are you post-certified?
I am.
And were you post-certified in January 2020?
I was.
In January 2020, was that during the period you were assigned as an Apex, with the Apex unit?
Yes, ma'am.
And as an Apex officer, did you have a particular area in which you were assigned?
No, ma'am.
I want to take,
No, ma'am.
I want to take you specifically to January 21st, 2020. Do you have the occasion to respond or be at 151 Cleveland Avenue?
Yes, ma'am.
And is that in Fulton County?
Yes, ma'am.
What is located at 151 Cleveland?
I believe it's an Exxon gas station.
And why were you at that location?
Myself and my partner were at the location doing targeted enforcement. We had observed a group of males quickly flee into a gas station upon seeing our patrol car.
What happened once you saw the man quickly flee into the location?
Upon seeing the males quickly flee into the location, we stopped and made entry into the gas station.
Okay. What happened once you went inside?
We went to the back of the store by the gaming area where there's gaming machines. This is the back of the store where there's an enclosed space with the door where they keep little the electronic gaming machines at the back. And it was in that room we discovered 3 males that had run inside.
Okay. And what happened once you went inside the gate?
Took in general conversation, talked to them, and then 2 of the males came outside with us.
Okay. And what happened once the 2 males came outside?
Upon the 2 males coming outside, had a general conversation with one of them, asked him, hey, what was going on? You know, if you have anything, let me know. We can go ahead and deal with that. But once again, it was only 2 of the males.
Okay. And did any of them say they had it?
Yes, I believe Mr. Ford self-reported having a small amount of marijuana.
Okay. He said Mr. Ford, do you remember what his first name was?
I do not.
Okay. We're looking at a copy of your police report, how refreshing.
Yes.
Permission to approach, Your Honor?
What are you marking?
95R, his police report.
Okay, all right.
I'm going to show you what the mark is. Identification is 95R. Tell me if you recognize 95R. How do you recognize it?
This is the police report based on our old report writing system.
Okay. And looking at your report, does it help you refresh your memory as to the first name of Mr. Ford?
It does.
Okay, where was Mr. Ford?
Darius,
And once he self-reported, what happened?
he was detained without incident.
Okay. And what happened to the other male?
The other male was free to move about, go about. He had nothing on him, so he just sat there.
Okay. And then the third male, what did they do?
Mr. Beebe, I observed he was not there. He actually was still inside the room, the gaming machine room.
So when you recognize he was still inside the gaming room, what happened?
I went in there to speak with him and get him to come out.
Okay. And did he come out?
He did.
All right. What happened once he came out?
Upon him coming out, he was sat down, and then I went back into the room.
And we said he sat down. Where was that?
Sidewalk in front of the business.
Okay. And why did you go back inside?
Given the fact that all the males had come out except him, I wondered, okay, well, why were you staying inside into that room? You know, did you possibly leave something behind?
Okay. So what did you do once you went back inside?
I went back into the gaming machine area, and in the direct spot where Mr. Beebe was at, I discovered a small baggie containing half a gram of crack cocaine.
Once you found the crack cocaine, what if anything did you do?
The first step was to detain Mr. Beebe and explain to him why he was being detained.
Okay. And what did you do next?
Next, we talked to the store clerk and see if we could view surveillance footage of that store, of that room, to see if they had a camera back there.
And were you able to see any surveillance video?
Yes.
And did that surveillance video confirm or deny what you had picked up inside of that room?
Yes, ma'am.
And after you observed the video, what, if anything, did you do?
Mr. Beebe was formally arrested. He was formally arrested for possession of crack cocaine. Being we had seen him take the crack out of his boot and discard it in the area where it was located.
And what, as this Mr. Ford, was he arrested?
He was issued a copy of the charges for possession of less than an ounce of marijuana.
And did you collect the crack cocaine from Mr. Beebe?
Not directly from Mr. Beebe, but I did collect the crack cocaine that was recovered, yes.
And did you turn it into evidence?
Yes.
Permission to approach the camera?
Yes, ma'am.
I'm going to show you what's been marked as State's Exhibit 79, 80, 81, and 82J. Please tell me if you recognize those.
79J is, I'm
Do
sorry.
you recognize them?
Yes.
How do you recognize them?
These, I believe, come from my body camera.
Okay. And what are they of?
79J appears to be of the vehicle I was driving that day and the outside of the gas station.
Okay.
80J, once again, is from my body worn camera. It's the outside of the gas station. 81J, I believe that's Mr. Darius Ford. And 82J is Mr. Durante Beebe.
Okay. And is that a fair, accurate depiction of both the Exxon gas station and Mr. Ford and Mr. Beebe from January of 2020?
Yes, ma'am.
All right, this time stay with like, stay with like State's Exhibit 79, 80, 81, and 82J into evidence.
Officer Stansel, have those pictures been changed or altered in any way since the time that you saw them in January
No, sir.
of 2020?
No, sir.
Okay. Any further or any objection? Question still remains. Any objection?
No, Your Honor.
All right, hearing none. States 79, 80, 81, and 82J are admitted and may be closed as you see fit.
Thank you, Your Honor. First, we'll start with State's Exhibit 79. Showing State's Exhibit 79, if you can just orient the jury, what is State's Exhibit 79?
Just direct question directed to me.
Yes.
So the vehicle marked 31242 was the police vehicle, marked police vehicle I was operating that day, and the male standing next to it was my partner for the day, Officer Pagan. That's also the outside of the gas station.
Okay. And is there,
Pagan?
and is that 151 Cleveland Avenue?
Yes, ma'am.
Looking at State's Exhibit 86.
Once again, that's going to be 151 Cleveland Avenue.
All right. And now looking at 81 J. Who's doing it? The 81 J.
That is Mr. Darius Ford coming out of the game room.
Okay. So that is the game room that you just described earlier in your testimony.
Yes, ma'am.
All right. And then looking at 82 J.
That is Mr. Durante Beebe.
All right. Now, I'm also showing you what's been marked as State's Exhibit 78J. Tell me if you recognize State's Exhibit 78J.
Yes, ma'am.
And how do you recognize State's Exhibit 78J?
I believe this is the crack cocaine which was recovered.
And looking at 78J, is this the evidence bag that you would have used in order to collect that crack cocaine?
Yes, ma'am. The evidence bag and the evidence marking tags we use.
Okay.
And on here, does it have any other identifying information as to where it was collected, when it was collected?
Yes, ma'am. So marked on the suspect line, it has the name of Devontae Beebe, which is the male that was had it.
Your Honor, this time state like the tender states exhibit 78J is happening.
Which one, I'm sorry?
78J.
Any objection to state 78J? All right, states 78J is admitted and may be published as you see fit.
After arresting Mr. Beebe and giving Mr. Ford a copy of charge, did that conclude your involvement?
Yes, ma'am.
All right, I just.
Cross. Anyone?
Yes. Sorry, Judge, we'll go with it next time.
Morning, sir.
Good morning.
Stansel, right?
Yes, sir.
All right. So let's see. Your involvement in this case is that you come to the location, and as you and other officers pass that location, you see folks run inside.
Yes, sir.
Okay. And that was enough to make you all stop and go inside and pursue and see what was going on, right?
Yes, sir.
All right. You hadn't seen any crime being committed at that point, right?
No, sir.
Where is this location?
151 Cleveland Avenue.
Okay. How many of you guys, law enforcement officers patrolling at that time?
I can't answer that question. I'm not sure.
Okay. Roughly how many cars? More than one car?
In that area,
Well, right there at the scene. What we're talking about right now.
we were the only responding car at the area at the time.
Okay. All right. And so, see some guys run inside a store. You guys going inside. You rotation in there or just running?
Just walked in.
All right. You go back. You encounter these folks, and you make them come outside. Yes.
Yes, sir.
All right. Anybody handcuffed or anything like that?
No, sir.
Okay. You're just talking to them at this point, right?
Yes, sir.
And at some point, if I understand correctly, you found what you believe to be a rock of crack cocaine, and Mr. Beebe was charged with that.
Yes, sir.
All right. And you remember the incident. You remember Mr. Beebe.
Yes, sir.
All right. You don't see him here, right? He's not in here.
Not to my knowledge, no, sir.
Okay. That's the only thing you charged him with, right?
Yes, sir.
All right. You didn't have any reason to, and you certainly did not believe there's anything to charge him with other than being in possession of a rock of crack cocaine, right?
I charged him accordingly based on the facts of the case. Yes, sir.
All right, according to the facts of the case.
Yes,
so
sir.
what you're testifying to is exactly what happened that day and everything was involved on that day, right?
Yes, sir.
All right. You ain't charged with a gang crime, did you?
No, sir.
No basis to it.
No, sir.
All right. That's all I have. Thank you, Judge.
Anybody else? All right, any redirect, madam?
Nothing for the station.
All right. At this point, may Officer Stansel be permanently temporarily excuse the witness?
He can be permanently.
All right, Officer Stansel, thank you for your patience with us. I'm going to go ahead and permanently excuse you as a witness. Don't discuss your testimony with anybody except the attorneys in this case, okay? Are you good?
Yes, sir. Thank you.
Okay, all right. All right, ladies and gentlemen, it's about 12:20. How about some lunch? Okay, all right. So, ladies and gentlemen, we're going to recess, and I'll have you come back for 1:30, and then we'll see whether just make sure. All right. All right, ladies and gentlemen, at this point in time, what I'm going to do is excuse you for lunch. We'll come back at 1:30, and then we should be working till about the hour I told you yesterday, somewhere between the 5 o'clock hour, and then we'll recess for the day, and I'll tell you about the plans for tomorrow. Remember the admonitions I've given you. If you should go out of your headquarters for lunch, please leave your notepads in the basket, and remember not to discuss this case in any way amongst yourselves while you're back there or in small groups or any other places. And if anybody should, in fact, try and talk to you, please let me know, okay? All right. You have any questions of me, ladies and gentlemen?
No, sir.
Okay. If not, have a nice lunch. We'll see you back at 1:30. All rise. All right, ladies and gentlemen, please be seated. Our jury has left us. All right, we'll see you all back at 1:30 for continuing with the case, okay?
Would you mind, over lunch, I'm going to, with court's permission, send you a proposed instruction, what I asked previously, that unless and until a conspiracy is proven and the jury has to learn the law from you, that these acts, just the individual people's acts, unless and until you decide otherwise on purpose. I know you gave us a continuing objection. I asked that all the other persons who are not here, their acts be severed and not discussed. I know you objected to it, but
I didn't object to it. The state did. Okay, all right.
the state objected and
Yes, sir.
overruled by the motion.
Yes.
But I'd like you, if you don't mind, I'd like that to be considered.
Your Honor, the state's going to object. We are putting up our case, and so as we're putting up our case, there's an instruction we believe will be improper at this juncture, given that we are in our early stages of our trial. We're putting up our case. This is a conspiracy case, and that can come at the end. Now, at the end, maybe during a jury instruction, at that time, the jury can decide whether or not these are individual acts or not. But we are putting up our case. We have alleged that the individuals we are putting up, these cases are part of the conspiracy. And so we are putting up our case. And I believe it would be improper to instruct the jurors at any point in this time about the particular acts that we're putting up and how we're putting up our case.
All right. At this point, Mr. Steele, I'm inclined to just to wait till the end of the case and determine if based on the evidence presented, whether or not I'll give an instruction as of that. But, I mean, you're welcome to send it to me, send it to the state. I'll look at it, but I'm not inclined at this point in time to go ahead and give such an instruction, okay?
I understand. Can you just give the continuation?
You've got a continuing objection, sir. I've already say that for the record. Okay? All right, but you're welcome to send it to me. I'll take a look at it. All right, we're in recess. See you all back at 1:30.
Please keep them coming because I couldn't have two better guests. Terry Austin is with me. She is a host and a legal analyst here at the Law&Crime Network, and Brian Buckmeyer, a legal analyst at the network. Guys, this is kind of amazing because we got some great questions. Sarah, I'm going to start with you. Mimi Windu Question has a question, and that is, what is your opinion on how the trial will be concluded? Well, that's a pretty big of a whopper for a trial. It just got started. It's got a long way to go.
It does have a long way to go. And Mimi, I think that we're going to see lots of evidence. We're going to see lots of witnesses. We know already that the prosecution has said they're going to have, well, a list of 400 at first, but now that has been whittled down. And so I think it's going to be really difficult for that jury to focus and remember all of the evidence. So ultimately, I think the conclusion might be, and this is a guess and a forecast, as to some of the defendants. Remember, we have 6 different defendants here. Some of them, they may just not be able to come to a conclusion unanimously. So we may see a couple of mistrials here. I'm not saying that's going to happen, but I think it's a possibility because it's so big.
No, you didn't. You were anticipating another question that we're going to get to in a minute. But, you know, something that when you're a prosecutor and you have a case of this magnitude, it's got to be tight and easily deliverable and understandable. Any too long, too much confusion is never good for prosecutors in the state. Brian has had a little bit of a rough patch here in getting their case started from the beginning, but I'm gonna ask each of you this question because they're asking, and I'm sorry, let me go to the Gospel of Kenneth. How many mistrials are allowed on one particular case, speaking of mistrials?
Didn't the Gospel of Kenneth preach about this last time?
Yes, he did.
Well, praise be the gospel. But I think there's no limit as to how many mistrials. One, it would depend on what the mistrial was for, whether it be because it's a hung jury or whether because information came in that wasn't supposed to, and so the judge issues a mistrial. But it always goes back to the prosecution, and they have an ethical duty to only bring cases in which they believe they can get a conviction for. And so if there's a mistrial and they think they can still get a conviction, then theoretically they just do it again.
Yeah, and I'm thinking of cases like John Gotti Jr. and the Menendez trial, where eventually sometimes prosecutors have to give up the ghost and say, look, it's just too much. A lot of times the court will put pressure on you. You just can't get a guilty verdict in the case, and prosecutors will have to make that decision, and they can differ on that. So here's another great question for both of you guys, because we're being asked to be really honest, or at least you two are being asked to be really honest. Invisible Woman from YouTube wants to know, quote, to be really honest, have you ever seen a case like this in your time of being a lawyer or any time in your career? If so, how did it end, Tara?
Well, Invisible Woman, no, I've never seen a case quite like this with so many defendants starting out. I think prosecutors are a little intimidated when you have this many people that you're going after. That means you're really going to have to do your homework. And I think that's why we've seen some issues as far as discovery is concerned here, because the prosecution is having a difficult time putting their case all together as relates to all of these defendants. So it's big, and I think that's why it's very different from other cases. And I can't say I've seen a case with this many defendants before.
Yeah, we'd really love to know, Brian, like, how did prosecutors, if at all, try to narrow this down so that they went after the biggest people and made it as tight as possible, because it can get really unwieldy. As a former prosecutor, I'll be honest, I've never tried a case of this magnitude at this. I've tried them as long as this, but they were very narrow and focused issues on singular and double and 3 times crimes, not something as expansive as a RICO. So, Brian, if you were being honest, have you ever seen a case like this in your time as a lawyer? And if so, how did it end?
Well, Invisible Woman, I see you. It's a great question. I think the important numbers here are 6, 9, 28, and 191. 6 are the number of defendants that we have now. 9 are the ones that took a plea. They're always going to be there in the background, because the question I think that you've alluded to in prior answers and questions is, what are they going to testify to? What are they going to say when you get there? So you can't just represent your client and think about what's going to happen with the other 5 there, but the other 9 as well. The other issue is this case started off with 28 defendants, right? So if the prosecution whittled it down to anything, they whittled it down to 28, which is a massive endeavor. And the 191, that's the amount of overt acts that they're going to try to prove. Any one of those can have your client convicted if it's attached to a charge associated with them. And so this is massive. But to answer the question, honestly, no, I've never seen a case this large. Have I seen 6 case defendant cases? Absolutely. But you don't have 9 people in the background. You don't have 12 people awaiting a trial. You don't have this starting for 28. I think the only time this county's actually ever seen this is, I think, DA Willis went after the school boards, where they had a similar RICO charge. And the next time we're probably going to see this again is when former President Donald Trump gets prosecuted. So this is a very, very rare type of case.
Yeah, and you make it a really good point. And I think those defendants that have pled, to the extent that they're going to cooperate and give testimony, and how believable they will or will not be, could be the thing that makes up the room for the difficulty the prosecutor at least is facing at this point in time, again, assuming they come off as credible. Great questions, guys. Keep them coming. We're going to take a break in the meantime. We'll be back on the other end. Please stay with us. Welcome back to Law&Crime. We are in Georgia following the racketeering case against rapper Jeffery Williams, better known as Young Thug. Williams and 5 other co-defendants are on trial for participation in a criminal street gang called Young Slime Life. The courtroom was sent away for lunch, so that what gives us an opportunity to answer some of the viewer questions. If you have a question you'd like for us to answer, and I got 2 great guests to do that, then you can go onto our social media and YouTube channel, and maybe you'll get up there. Just like, guys, Evan Parrish from YouTube is asking us on a scale of 1 to 10, Brian, it's a 1 to 10 scale. How biased towards the state does this judge appear to be to you? Seems the state's objections slide through easily, while defense objections are always overruled. Clear bias, question mark?
All right, so I'll use the scale. I don't believe there's a bias here, so I would probably put it more towards a 4 or 5. What I would say is, in an evaluating bias, and this is, I'll say this, I might be wrong. I might be 100% wrong, but I would give you the tool to do it. So don't evaluate the number of sustains and overruling. Look at the value of the objections, because I will say things as a defense attorney that should absolutely be sustained, but I'm also doing it strategically in terms of I might just want to object to mess up the flow. I may object because, you know, I just think it's wrong, but I don't have the strongest argument. And so you want to see what they're objecting to, not necessarily how the judge is ruling. That's a better gauge, I think.
Yeah, go ahead, Tara.
Yeah, I also think that the judge is being fair. Judge Glanville is looking at both sides. Now, he might say to the defense, objection overruled, because he wants the case to continue at a faster pace. But we've seen in this trial the fact that the judge gets angry at the prosecution for lack of speed in turning over discovery. So I think all in all, the judge is being fairly even-handed. So I would rate it as even-handed.
Yeah, I got to be honest with you, I feel the same way. And in fact, the judges undressed, or the pants, as we would say, the prosecution on a number of occasions. So, you know, sometimes, like Brian is saying, it's the quality of the objections that matter. And the defense attorneys are getting sustained objections does not mean the judge is being biased. And again, the prosecution has been attacked there. Okay, Matt from YouTube, what is the furtherance of the gang that the state is claiming? The overt acts so far don't seem to support any furtherance. What is the furtherance of the gang that the state is claiming, Tara?
Well, I agree. I think so far we have not seen the prosecution connect the dots. What we've seen is evidence of these acts, these stops that they made when they arrested people for possession of drugs or possession of a gun. But there was no discussion during any of those arrests about gang activity. So what the prosecution still needs to do once they establish all of these acts and gets all of them into evidence, they're going to have to some way connect those acts. So they'll have telephone conversations where you have a conspiracy with the other defendants that, you know, they were acting in furtherance of the gang activity, that the money that they got perhaps from one of these, you know, stops that happened went towards some illicit criminal activity. And that hasn't been done quite yet.
You know what? What's really amazing, Brian, is that there are individuals who can watch a show and understand it and go about their lives and do what it is that they do. But I think very few would actually listen to what Brian Buckmeyer is saying and then say to themselves, I need to have a follow-up question from something that Brian said. So this one's for you.
Oh,
this is the first time I've seen this. This is a for Brian question.
Is that Victoria Buckmeyer? Sweetheart, come on, stop doing this.
Well, it could be, but this person's going by the name Real with Robo. Does that sound familiar?
Yes.
It does sound familiar. Okay. Brian, you said yesterday that thus far you don't see the connection in these past incidents. I don't either. How about so far today?
No, not as yet. And something happened, and first of all, thank you again, one, for watching back to back, but also for the question, Real with Robo. I don't see it. And I'll kind of piggyback off the last question, what Terry was saying as well. We saw something yesterday, for example, and we're seeing it today with the drug paraphernalia as well, where there were 16 grams of a drug on a person. Just to give you some kind of math, I know this because I'm a defense attorney, there are 28 grams to an ounce. 16 grams in most states is personal use. 16 grams, you're talking about, if that's marijuana, that's like a few joints. That's not a criminal enterprise that you are now profiting off of to further a gang. You gotta show me somehow that because Young Thug had a gun in his car, that's somehow furthering a gang. Now, if you said, Young Thug had a gun in his car and he drove past a neighborhood and he flashed out and said, if you come by my block again, you're gonna get this, then I say, yes, he's defending his territory and that's furthering the gang. But simply having drugs, simply having a gun, I don't see how that furthers a gang.
You want to opine on that, Terry?
Yes.
Because it looks like you do.
And here's why. You saw Nicole Westmoreland, who is the attorney for Mr. Nichols, and she was cross-examining that forensic expert. And she harped on the point that, this was only it didn't even reach 28 grams for most of what they were looking at. And so 28 grams, to Brian's point, is nothing. It's a misdemeanor. It's a small amount of marijuana. So I think she's trying to prove here that none of these are going to connect up to any sort of criminal activity. And not only that, these are small amounts, and why are the police stopping these individuals and, getting information on small amounts that aren't intended to be distributed or sold?
Yeah, interesting. All right, Terry, I'm going to go back to you on this. Colin Cooper from YouTube says, everybody who took a plea deal took it while locked up. Doesn't that look terrible on the prosecution? They let people go with 1 year time served and probation who had 50 plus years over their head. This is really a sophisticated and nuanced question tactically that we as prosecutors and defense lawyers look at all the time. What do you think, Terry?
Well, one of the things the prosecution is considering here is, are they going to get convictions? As Brian mentioned before, we started out with 28 defendants and we're down to 6 for this trial. Others, have pled guilty. And what the prosecution is going to try to do is use that information against the remaining defendants. So we know for a fact that they may be calling some of these other defendants. Now, these defendants could take the fifth, but we think if they're called, they'll probably support the prosecution's case. So it's a calculated, issue here. The prosecution is trying to figure out, look, how many people am I going to try? How many people can I get to take a plea deal? And will I be successful when I actually try the case? So it's not a bad idea to take some pleas in the beginning of the case.
Brian, we used to say as prosecutors, but it was always contradictory to me. When you sleep with dogs, you catch fleas, which was if you put one of those guys on the stand. But let's look at mob convictions. Let's look at organized criminal racketeering cases. A lot of times I had to put a person that got a plea deal that wasn't a great guy, but there's also something about the fact when I'm downstairs interviewing that witness that they just come off as believable and credible. Of course, that's what you hope when they get before the jury. And I've had some people who took plea deals, got substantial breaks that were incredibly powerful before the jury. It's a double-edged sword sometimes, though, Brian.
It is a double-edged sword. And understand this, I'm a former public defender, so my answer is going to be colored and biased with that. I can see that a reasonable person will say something completely different. That's where I start, but I go it this way. I think the heart of this question comes down to, you let people go with a slap on the wrist when they are facing far more jail time. And the criticism that a defense attorney, at least a public defender, would give is that they are looking for numbers, that a prosecutor's measurement of success is how many convictions that they get. And so for them, they are successful in getting 9 convictions. Even though they could have gotten 50 years out of a person but let them walk, it makes it seem like it wasn't that big of a deal. If you could have done so many more years, why are you walking with probation? But on the other side to this dual-edged sword, some of these cases, you need an inside man or inside person to testify to. So you've got to throw back the little fish to catch the big one. Because if you quote-unquote let King Slime go because you wanted to knock the lowest guy or the lowest person on the ladder with 50 years of jail and they won't testify against King Slime's just going to go recruit another lower guy on the ladder. So it's strategic, but it also can have a bit of a bad look from a sense of you could have gotten a lot more from these people. It's just what's the greatest good that the prosecutor's trying to achieve.
Yeah, and that is going to be such an essential decision that prosecutors are going to make. And of course, let me add, for those who are out there looking to go into the prosecutor world, or if you're interested, a prosecutor may have to do that, like Brian says, to be on the inside, but you want to try to find objective outside evidence that supports what it is that that witness is saying. That's something that prosecutors will always look for under those circumstances. Great questions, guys. Keep them coming on the social media, on the YouTube. It's time for us to take a short break. We'll be back on the other end. Please stay with us. We're breaking down some questions here at our YouTube channel from our viewers in the Young Slime Life trial. The courtroom has been sent away for lunch. So let's get right back to it. Some of these questions have been great. Terry Rod Springs asks, at what point do you believe the judge will be inclined to dismiss this for lack of substance and evidence that this is nowhere near a conspiracy, let alone a RICO? Now, let me just to be clear, Terry, because we understand that there was a conclusion that there's nowhere near a conspiracy or RICO. We've just started this case, but nevertheless, at what point in time will a judge be required, if at all, to dismiss a case like that?
That's a good question, Rod. I believe that the judge is going to wait until all of the evidence is in. Frankly, it would be premature at this point for the judge to say, look, prosecution, I don't think you've shown anything yet. And at this point, you know, if someone were to move, if one of the defendants were to move to have that entire case dismissed, I don't think the judge is going to listen to that. It has to be after the evidence is in, a motion has to be made that, you know, they didn't prove the case beyond a reasonable doubt. And even at that point, I don't think the judge is going to say, oh, okay, I'm going to dismiss this. This is for the jury to decide. And the judge is going to allow the jury to come to some sort of conclusion here. So even if, Rod, you think that perhaps there's not enough evidence here, I think that so far, there is evidence, and the judge just has to wait until it all comes in. So we're going to see the conclusion of this trial one way or the other, unless there's some sort of mistrial, and we'll see.
Brian, we're going to get to another question in a minute, but just so it's clear, the judge isn't the arbiter of the facts; it's the jury that is. And to your point, they wait till the state presents all of its evidence. I presented a case that really wasn't solid until the very end, and the last couple of witnesses that tied it all together. The defense would be able to make an opportunity at the end of the state's case to dismiss it. All legitimate inferences are given to the state at that point in time. Very rarely would a judge grant that. The judge wants the jury typically, I know Brian knows this, to make the decisions with regard to that unless there's really absolutely nothing. I've never seen that motion successful. Brian, yeah, go ahead.
I had it once.
Yeah, you had
it. You call it a trial or dismissal. They couldn't get the video in. I won the case.
Oh, okay, right. So a substantial piece of evidence that was needed in order to prove the case. That would be an example of that. A witness that's supposed to be testifying, a victim that doesn't show up to court. You could be in the middle of the case, and at that point in time, that motion, you know, may survive at that point. But assuming what we see right now, I don't think that you can anticipate the judge is going to dismiss it at the end of the state's case. But obviously, we'll see what happens with that. Brian, Nurse Lala from YouTube wants to know why some officers' faces are seen and other officers aren't.
Well, Nurse Lala, thank you for that. That's confusing as well. Earlier on, we saw their faces, then we didn't. I think there was some issue with the camera seeing some of the jurors, and then the issue progressed to the law enforcement officers who are directly connected to the case. Don't forget, it's a gang case where these officers are not just officers of the laws, they are probably husbands, fathers, brothers, uncles. And so they have families that they have to not only be protected for themselves, but also protect their families. I think that was the fear they had. But now we're seeing officers who are less connected to the case being shown on camera. And I think it's about a safety issue from one officer to the next.
All right, we got a couple minutes left, but I really love these questions, and I hope we can continue to do this. Cavell O from YouTube, Terry, asked this question, and it's one a lot of people are debating about. Will the resolution of this RICO case and how it is handled set a standard for gangs and or criminal admission via social media, I guess, in the future?
You know, I do think it will have a chilling effect no matter how this comes out. Having a RICO charge here for this type of activity, I think the prosecution is really stretching a bit to say that all of this is connected. I mean, so far what we've seen is that each of these, you know, criminal activities have been for the benefit of the individuals. They still have to connect those dots. But if they are able to do that, then I think on the one side, prosecutors will begin to look at RICO as a way to go after criminals, and there's more flexibility in terms of the evidence that gets in because of that conspiracy. On the other side, if the prosecution gets a conviction here for one or more of these defendants, I do think that people who are rapping, these young rappers who are coming out and having lyrics, 17 sets of lyrics are going to be used, could be used in this case. The judge has already ruled that. So I do think it's going to have an effect on what people are saying, whether it's in their songs or social media.
Brian, real quick, because this is a great question. Just Chillin' here from Twitter said, since it's a RICO case, can one attorney object on behalf of a defendant who is not even his client? This person says, I think I saw Mr. Steele helping Mr. Short out of an objection regarding a witness against Stillwell. I got a couple.
Make it short. Yes, because it's not about the evidence that comes against your client. It's about the evidence in which the jury hears. And because it's one jury hearing evidence for all 6 defendants, you can object or help. Yes.
Yeah, and Terry, we got about 30 seconds. There's also circumstances in which there's some lawyering that goes on there where sometimes they can be agitated if they got to be on the same page too, because if they're not, somebody could be making an objection that could actually hurt their client. I've seen this happen many times where a defense lawyer made a comment that hurt all the defendants in the case.
Exactly. I think here they are coordinating to a certain extent. I've seen them lean over and talk to each other. I've seen them pass notes to each other. And so I definitely think, in fact, I saw Nicole Westmoreland send a note to Brian Steele. So they have 2 different people that they're representing, but they still have an interest to get everybody dismissed if at all possible. And that's what they're trying to do.
Excellent. Brian, I know you got to go, but Terry's going to be staying with us. So we're going to take a quick break here at Law and Crime. We'll be back on the other end. Please stay with us. still in Georgia filing a racketeering case against rapper Jeffery Williams, better known as Young Thug. Williams and 5 other co-defendants are on trial for participation in a criminal street gang called A Young Slime Life. The courtroom was sent away for lunch break, so we continue to answer some of the viewer questions. If you have a question you'd like to have answered, post your questions on social media and the YouTube channel, and hopefully we'll try to get to it. We've had a great hour with the questions, and I love doing this. Terry Austin is a host at the Law&Crime Network as well as a legal analyst. So let's go to it. Terry, we got one here that I think is interesting. Can a co-defendant defense lawyer approach another co-defendant without their lawyer present? This comes from Rosie Gar 49 from Twitter. So can a co-defendant lawyer approach another co-defendant without that lawyer present?
Normally, you have the prosecution and the defense, and it's one lawyer for the prosecution, one lawyer for the defense, and clearly they have contradicting and, interest in mind. But here, even though some of the co-defendants may have some of the same theories about the case, they may have some of the same defenses about the case, they still have individual representation, and you need to go through the attorney before you have a conversation, because there is the possibility that there could be a conflict there. So for instance, one co-defendant may want to point the finger at another co-defendant, and so if the attorney for one speaks to the attorney for the other, they need to have representation so that their interests are always protected. Good question, though.
Yeah, that is like an absolute in the world of lawyering. Anybody who is speaking to a represented client is going to wind up having an ethics charge filed against them. And of course, the consequences could be pretty dramatic, and prosecutors won't be all too happy about that as well, because it creates an appellate issue for them, not of their own making. It's bad enough when you create your own appellate issue, but not when there's an issue with regard to that, all right? A defense, let's work on this a little bit. I think this actually has a lot of depth to this, right? So a defense lawyer's responsibility, sacrosanct, is towards that particular client. And when you're dealing with a case such as this, one of the reasons why each person has to have separate lawyers is because there could be a conflict of interest. Even a lawyer who learns some information from a client, this happens all the time, learns some information from a client, and that client doesn't hire them, but then another co-defendant may want to hire them. Many times, Terry, they're going to be precluded from being able to take that case because they had gained attorney-client privileges from the co-defendant that they did not represent. That's how strong that is.
It is very strong. In fact, it came up in this case for Brian Steele. He is one of the attorneys actually for Young Thug, and he represented other defendants in similar types of cases, and the prosecution was actually trying to get him off of the case. I'm not sure if the co-defendant attorneys were trying to get him off the case, but that issue comes up because you are going to get privileged information from your client, and that information cannot be shared in any way, shape, or form. So it does make sense that if you represented one co-defendant, you would be very difficult representing another co-defendant in the same case.
Yeah, I mean, where's, and this is another problem, again, just in real world, in real lawyer world, what can happen under those circumstances is that information, what happens if you have information from the person that you do not represent that may be exculpatory, right? Like, in other words, may help out another co-defendant, but be inculpatory or hurt the original person you spoke to. Where's the defense lawyer's allegiance? To the first person they spoke to or to the second person they spoke to?
I've got to tell you, Bob, if that happened in real life, and if the attorney took that information and helped his second client versus the first client, he could be disbarred for that. There would definitely be some violations there of attorney-client privilege.
You know what we got to do here, Terry? We got to bring in Paul Townsend.
Oh,
Paul
yes.
Townsend, criminal defense lawyer. My man, Paul, how you doing, buddy?
Hey, Bob, good to see you.
Now, I got to ask you, I've seen it happen. I've seen defense lawyers that, in the real world, your phones are ringing in your office. That's why we have a very significant conflict checked in our office where there's co-defendants in a case. And if they consult with you and they give you information and you decide maybe they can't make the fee, or you decide you're not going to represent them, or they decide to go to another attorney, and then another co-defendant in that case comes in and you've now had confidences from two, separate people on the same case, there is a way to maybe get around it, but it's something that needs to be done with judicial approval, notice, and waiver of those clients. But talk to us about how lawyers fall into that trap and can find themselves in a very difficult situation.
It's very true. You can get into a lot of trouble doing this. And even in New York City, which, most people realize is a sprawling metropolis, the universe of criminal defense attorneys is not really that big. So this is a situation that happens from time to time where you'll meet with somebody, you'll speak to them, you'll try and figure out, am I the right lawyer for you? Should I be representing? You discuss the facts of the case, you get a sense of what's going on, where you are, have motions been filed, and then for whatever reason, they don't retain you. And now you have this information in your bank and you're thinking about it, and a co-defendant calls you and says, you're my guy, you've been recommended to me, you're so good, I really want to hire you. It's not a blanket, I can't do it, but like you said, the three things: you got to get notice, waiver, and approval, and you really have to be so upfront with everybody from the very beginning about your previous conversations. You've met with them, you've had access to material non-public information, and for you to take on the representation of that co-defendant, everybody has to be in agreement that this is okay. And if the prior potential client who came to your office says, I'm not comfortable with that, I told you things that could come back and bite me, then that's it. Then that's it. You can't do it. As you and Terry have both said, it opens the door to egregious ethics violations, and no attorney wants to get that reputational hit of somebody who is willing to have those conversations in confidence, in private, those sacred attorney-client conversations, and then turn around and use them to that person's detriment later. It's just a bad look overall.
Yeah, and I'll tell our lawyers that are out there that watch us are our lawyers to be, because I know there are so many that look at the advice that you guys give. You may not even realize it's a conflict at the time that you do it, and then later something develops during the course of the trial, and you're like, oh my gosh, something the other guy said is relevant to my client's defense. You just don't want to be in that position. So most lawyers, I think good practicing lawyers, are like, look, even if I don't really perceive a conflict now, I'm not going to get involved in what potentially could be a conflict down the road. All right, guys, listen, Just Chillin' here from Twitter asked the following question. Why is the state allowed to use the song Really Be Slime as evidence and say that Young Thug is rapping those lyrics when it's actually YNW Melly and Young Thug isn't even on that song? And why didn't Brian Steele bring that up during opening statements? I don't know if they know this or not. Terry, you know everything about this case. Is that making sense to you?
Well, listen, what I can tell you is Judge Glanville decided in the very beginning of this case that lyrics can be used against these defendants. So there are 17 songs that are allowed in, and the judge has stated that you have to lay the foundation, you have to set the relevance of each of these lyrics before they come in. But he ruled, look, for these we are going to consider as we go along throughout the trial. The YNW Melly case, just the opposite occurred. The judge did not allow lyrics to come in. And as a matter of fact, the prosecution said that she wasn't going after the, defendant here because that wasn't part of the case. She admitted that the lyrics to his case and his song had nothing to do with what he was being charged with, the murder of, two of his, collaborators that he was with. So I don't know this particular song that our viewer is bringing up, but what I can imagine is it doesn't matter who's really singing it. If the judge has said, look, I think there's some relevance here, we'll make a determination at trial, whether YNW Melly is singing it and he references Young Thug, or whether Young Thug is singing it and he references YNW Melly. The judge decided that some of these songs, some of these lyrics can come in, and the prosecution has to make sure that they've connected it to relevance.
Paul, I want to play devil's advocate on this because I had a very lengthy discussion in the gym yesterday with an individual who was very, very upset with the idea that lyrics are coming in the first place. And I think, as any good lawyer can, I can make arguments on both sides of the equation as to why it may not be relevant in a case. But, I probably get in trouble for saying this. Like hip hop is a genre, and it's not just hip hop or rap. Every genre, whether it's a romance or go back to Frank Sinatra back in the day, exaggeration and making up stories or saying things in order to emphasize a point is part of art. I mean, it could be part of a picture, it could be part of a song. I don't want to be alone, but I tried to explain to this individual, not that whether it should be admitted or not admitted, there's a difference in what the judge does when they say it's admissible and whether it may be relevant. That's in the evidence rules. I always emphasize that you got to look at the evidence book. And then a lot of times judges will say, I'm going to allow it. It's the jury's province as to whether or not they're going to bring any credibility into it. The other argument, Paul, on the other side is 403, as we call it, which says that a judge can exclude evidence, even if it's relevant and if it lead to undue confusion of the jury, excessive amount of time, or something that could confuse the jury. So where do you stand on this, or feel free to make both arguments?
So that was like 7 questions in one, and I'll try and piece them together as much as I possibly can. To me, and I've had this come up in trials that I've done, I've had clients that have fancied themselves to be aspiring rappers and have had lyrics on their phones that prosecutors have tried to admit. And I have fought tooth and nail to keep these out. In my opinion, this is nothing more than protected First Amendment speech and expression. It's an art form. It is not meant to be taken literally. It's like a novelist who puts pen to paper or fingers to keyboard and writes out something that somebody does. It doesn't necessarily mean that they are espousing that same value system, that they condone the actions that they're talking about. It's a form of expression. And so the idea that it could come in as evidence in a case, I take issue with, but I also, to play devil's advocate, I understand that there is a balancing process. And as you say, the judge isn't saying these are carte blanche coming in. There are still certain evidentiary thresholds that a prosecutor has to make to use these things. So they have to prove that they're relevant. They have to lay a proper foundation. And the defense attorneys, Brian Steele and all the other co-defendant lawyers here, are going to have an opportunity to jump up and down and say, a proper foundation wasn't laid. You haven't tied this to my particular client. You haven't shown that this is relevant. You haven't demonstrated how this is going to help the jury make the determination as to the ultimate issues in this case. And if the judge agrees, Judge Glanville is free to say, you know what, you're absolutely right. I don't think that you've met that threshold. And in this particular instance, these lyrics are out. You're welcome to make a different argument for the next set. So I do think, to me, rap lyrics have no basis in a criminal trial. I don't think that they are sufficiently indicative of somebody's state of mind, but I understand why a judge would allow for the argument to let them come in.
Yeah, it's been something that's been hotly debated by a lot of attorneys, and I would imagine. Okay, and I'm going to ask you one more question before we take a break. Let me change the scenario a little bit. It's like law school. We do law school. Now, I'm going to ask you one question. It may have many pieces to it, but it will be one question. Trust me, not 7. It'll be 1. Okay, so let's say, for the sake of argument, these lyrics are extremely specific. These lyrics talk about, I hate my wife. I'm going to go out there. It's just a matter of time, and I'm going to decapitate her right on 5th and Elm. And then down the road, 2 years later, the wife winds up decapitated on 5th and Elm. Would that change the equation?
To me, no. I mean, you could say these guys rap about possessing firearms or trafficking in narcotics, and if one of them gets arrested later, with a bag of cocaine in their pocket, do I think they should be allowed to introduce the lyrics where they talk about how much they love selling drugs on a street corner? The answer is no, because despite whether or not the lyrics themselves bear some resemblance to reality, the idea behind a rap song is not necessarily to tell the story exactly how it happened. It is to express yourself through the art form of rap or hip hop or rock and roll or whatever it is. So just because art imitates life doesn't necessarily mean it is relevant to show that things happened exactly the way that the rap song says they did.
Yeah, very good analysis, guys. And I'll tell you what, I think you have to be extremely careful, even if it were to ever be admitted, to make sure that this is really something solid and also not infringe on that bad character testimony, that you're basically making them look like they're a bad person simply because they write it. It's a really fascinating area, guys, that I'm sure is going to be debated in this case and others down the road. But take a quick break. We'll be back on the other end. Please stay with us. right, we're out of Georgia following a racketeering case against rapper Jeffery Williams, better known as Young Thug. The jury is out to lunch right now, so it's giving us an opportunity to speak to our people out there on social media, on YouTube. Got some great questions. Keep them coming in. I got two awesome guests that can answer them for you, so let's get back to it. I like this question because I love the ones that are the practical questions, guys, that talk about the real life of a lawyer. Tall Glass from YouTube asks, do the judges seek advice on trials they're currently residing over? And if so, who, Terry?
Oh my goodness, Tall Glass, that's a great question. They absolutely do. Most judges have law clerks who sit next to them, and as a matter of fact, they are giving information sometimes to the judges in real time. We saw that with the civil trial against Donald Trump, where the law clerk was actually criticized by Trump's counsel. So the judges absolutely get information, they do research, they talk to other judges, and they want to make sure that they are making decisions correctly. The last thing any judge wants is to be reversed on appeal. So they have to look at that law, make sure they're making the right evidentiary decisions, and a lot of the questions that the judge has to answer relates to, does this evidence get in? And to your point, Bob, we were talking about 403 evidence, et cetera. They go back, they look at those rules of evidence, and they make sure that they look at the case law and apply it to the facts of their case so they can make the correct decision. So yes, Tall Glass, they definitely do go to others and use research to make sure they're making the right decisions.
Yeah, Paul, this is where I think that a lot of people, and I try to explain to my clients, or even when I was prosecutor trying cases, that if it was so easy to do evidence rulings in a trial, you wouldn't need to go through law school and you wouldn't need to get trained. But there's a big old book of evidence rules. I call it the Bible. So when I'm training people, I'm like, I want you to know those evidence rules inside and out. Those evidence rules are the guardrails, right? It's like a football game. If you pass the ball and a guy catches it outside the line, it is not a valid pass. And it's kind of like the same thing with evidence rules. There's hearsay rules, there's what we call 404 other act evidence rules. And the judge, in many cases, it's not the same thing over and over again. And they have to be very particular to get it right. And I used to feel as a prosecutor too, that's even more important for a prosecutor. And I know you may disagree with that, being more, I know you were a prosecutor, criminal defense minded, because at the end of the day, if the prosecutor gets a conviction and they find that the judge violated the evidence rules, there's more of a likelihood that that conviction is going to be reversed. You really have to know what those rules are. So I find also judges will also consult with other judges. Hey, I've got this unique evidence issue here. I've never handled it before, because all those rules that are in that book, right? Yours are probably about that thick, mine are about that thick. Every one of those rules comes with about 1,000 cases that interpret that rule. So talk to us about how important it is for the lawyers and the judges to really know those evidence rules well.
It's one of the most important things about trial practice, because in every trial, every single trial, there are issues that will come up that are going to be hotly contested between the parties, and both sides are going to think that the evidentiary rule supports their position. And as you said, it's so important for a judge to get it right, because judges don't want to be overturned. Defendants don't want to be potentially wrongfully convicted and then have to go up on appeal and hope the appellate division agrees with them. But prosecutors also, they want to maintain the integrity of their cases. And good prosecutors recognize that their job is not to convict everybody, it's to make sure that justice is done. So they want to do the right thing also. And it's so important for a judge to be able to know this, because as you say, you're on the fly there. A lot of times you don't have the luxury of being able to put off, it's 2 o'clock, I'm going to think about this issue for today and we'll come back tomorrow morning. You're expected as a judge to just have the answers. And it's really impressive for a lot of these judges who deal with these high profile cases, who make these incredibly complex evidentiary issue rulings and who have these reasoned, thoughtful decisions that they give on the record while the two attorneys are still going back and forth arguing. It's a really, really incredible thing to observe. These judges have this book of knowledge on the rules of evidence, and they're able to interpret 25 different cases on some minute point that coincides with the rule of evidence and deliver something that both parties have to just kind of sit and agree with. And a good judge will make it so that even the party that loses understands exactly why they're losing.
Yeah, and they have to make a really good record of it. How many cases have we covered on the Law&Crime Network that we're covering again on retrial because there was an inappropriate evidentiary ruling that later the appellate courts or the Supreme Court reversed? In fact, we're going to be discussing one probably later on today. And as a prosecutor, thank God that's never happened to me, but I was always very cautious that I wasn't stretching too far in the evidence rules, and that if the judge was making a mistake, that I jumped up and said, this is a mistake that's going to cause a reversal, and get the defendant to say, no, judge, I'm okay with the ruling, because that is something that would be relevant on appeal. So there's a lot of tactics that go into make sure that doesn't happen. Guys, a lot of great questions that we have right now. And Kenzie Davis from YouTube, speaking of appeals, Terry, says, has anything that has been discussed this far, and things are jumping around on my screen here, so it's a little difficult, discussed this far into this trial, reach appellate standards?
You know what, Bob? I have not heard that. I think that's a great question. I haven't heard that so far in the trial. I mean, the biggest issue I think Judge Glanville has decided was this evidentiary question as to whether or not the song lyrics could come in. And he said that they are admissible, but as we discussed before, you still have to lay that foundation. You still have to prove that there's relevance to it before it comes in. So I think the judge made a good decision by saying it still has to pass the rules of evidence. He didn't just say, okay, all the lyrics can come in. But I do think it's a very controversial issue here. I mean, as Paul said earlier, this is something that is being used against rappers. If you look at all of the other areas of entertainment, that's not used against them. If they talk about a murder, it's not used against them when there's a movie about it. And, I think here there is some bias going into this because rappers have this particular view and they have this particular culture, and prosecutors around the country are using that against them. So I think if there's any grounds for appeal, it could be the lyrics. And, so far I haven't seen anything else that was evidentially wrong.
I was bringing up something. There are people who are hip hop rappers that have never grown up on the street or in the inner city, but they're writing on the genre. They're writing the facts. They're writing the thing in order to communicate or speak to that particular audience. Don't disagree. I think that's why it needs to be very, very carefully done. All right, Kalea, India, hope I got that right. Augusto from Facebook asked, this is another great one, Paul, do emotions matter when it's a big case with a lot of defendants with this magnitude? Emotions, everything is about emotions. Does it matter in a case like this?
Do emotions matter? Emotions always matter. And when you're an attorney, you have to find the balancing act between using emotions and facts, because trial work is 75% factual and the other half is showmanship and emotion. So you're there as a circus barker, you're there as a tour guide, you're doing 100 different things to try and win the jury to your side. And one of the ways that you do that is to appeal to their emotions. You want them to be sympathetic to your client, you want them to be understanding, you want them to feel what your client feels, his fears, his shame, whatever it is that is going to be helpful for you. You are tugging at those jurors' heartstrings. You want them to experience real, raw emotions when they're looking at your client, and you want them to experience the emotions that are beneficial for you. The prosecutor, of course, is going to want the other way. He's going to want the jury to look at the defendant and get angry. He's going to want them to be burning up. And a lot of times, one of the objections that we as defense attorneys make is, Judge, he's just inflaming the jury. He's just inflaming the passions, the emotions of the jury. He's putting up photographs that are graphic because they're stirring up the jurors' emotions. So emotions definitely play a huge role in trial work.
Maya Angelou, not what you say, not what you do, but how you make people feel. Paul, I want to go back to one question that Kenzie Davis had asked and get your point of view in this, because as I'm thinking about the case and Terry's just answer, is anything we discussed as far that would create appellate issues? Now, me and you have talked about this specifically. Every state is a little bit different on what their evidence rules are. They're generally the same, but they're a little bit different. And to what level an appellate court will tolerate an error is a little bit different, whether it's plain error or not. There's all these different standards that they use. Something that I found to be really shocking is that when I train prosecutors, you tell me what your thoughts are. The number one way, at least in my state, that you are going to get reversed is by overreach in your opening statements or in your summation. Because what you say, and even though the court says it, is not evidence, they do tell you to listen to the attorneys because what they have to say is important. And I mean, I have seen courts reverse on things that I've read over and over again, and I'm like, they talk about flipping the burden to the defense or commenting on the defense's right to remain silent. And it can happen so easily, typically in summation, when a prosecutor's agitated, they're not that seasoned, where they can make an inadvertent comment that otherwise could be perceived that way. Were you surprised at the opening statement that the prosecutor made that was objected to, that in my opinion, clearly flipped the burden during the opening statement? What were your thoughts?
I knew exactly where you were going the minute you talked about your training of young prosecutors, because we have had this conversation before. And that opening statement, I do think, can very easily present some serious appellate issues for burden shifting. You know, the prosecutor basically said, you're not going to hear any evidence from the defense on X, Y, and Z. Well, the defense isn't required to present any evidence on X, Y, and Z because the burden stays with the prosecution for the entirety of the trial. So a prosecutor, it's not proper for a prosecutor to make comments like that you're not going to hear the defense attorneys argue whatever it is, because they're not required to. And you're putting confusion out there into the minds of the jurors. You know, well, am I supposed to be hearing that? Is he supposed to convince me of that? Is that his job in all of this? And the answer to all of those is no. The prosecution bears the burden. And when you make comments that slide the burden or shift the burden, even if you don't explicitly say it, if the insinuation, if the illusion is that the defense should be proving something to you that they are not, that is reversible error. An appellate division is not going to look kindly on any lawyer, any prosecutor that tries to even subtly convince a jury that the defense has an obligation to prove something to them.
Yeah, and those courts don't care whether you did it inadvertently or advertently. The bottom line is, at least in our courts, they make it very clear you'll feel the pain. And in a certain sense, you may be giving the defense a crack at a free trial, because that is a significant appellate issue that will be raised. You can be assured if there's a conviction. All right, guys, awesome commentary. Great questions. Keep them coming. We're going to take a quick break. We'll be right back. Welcome back to Law and Crime. If you're just following us, we're still in Georgia following the racketeering case against rapper Jeffery Williams, also known as Young Thug. Williams and 5 other co-defendants are in trial for participation in a criminal street gang called Young Slime Life. The courtroom has been sent away for their lunch break, and we've been able to have our great guests answer a lot of the questions that you are posting on social media and on our YouTube channel, and I love them. All right, listen, I mean, really, these are really great questions. I really mean this, folks. Invisible Woman from YouTube says, Paul, if Jeffery Williams is not convicted, will he be able to come back and press charges against the state for putting false charges against him?
That's an extremely difficult thing to do. In order for somebody who has been arrested and who either wins a trial or even has their charges dismissed by the prosecutor, for them to come back and actually effect a lawsuit against the police department, against the city, against the prosecutor, there's a really high bar of showing of malicious misconduct. Basically, you have to prove that the prosecutor or the police knew that the charges that they were bringing were false and elected to do it anyway. And you have to be able to prove that. So it's not enough that you're acquitted. It's not enough that you think that the prosecutor knew that you didn't do it before the trial started. You have to have concrete evidence showing that there was direct knowledge of your factual innocence and that they decided to prosecute you anyway. It's a very, very hard thing to show. It is possible in very limited circumstances, but it is extremely rare.
Well, Terry, I used to engage in the impossible because there were times where I had, and I'm surprised more criminal defense lawyers were not in the civil rights world. But to Paul's point, it is a very complex area of law because you have federal civil rights violations, you have state violations, you have violations for malicious prosecution, false arrest, and on top of it, there's different filing requirements from state law versus federal law. I used to love it because it was really complex, right? But in the end analysis, in federal law, for example, for a federal civil rights violation, you have to show a custom, practice, or policy of deliberate indifference. It comes from the name of a case, Monell. And to Paul's point, while it doesn't require necessarily that you knew, it requires pretty much that you were aware that your customs, practices, and policies were deliberately indifferent. And then this is where the big argument has occurred over and over again. We especially heard it during the George Floyd time period and during those kinds of cases. A lot of states also impose immunities, okay, which basically say, if the officer or the entity or the government officials were acting objectively reasonable, even if they were completely wrong, we're not going to allow them to be sued. So let's get into the politics of it, right? Because I used to go crazy when nobody would really discuss it. I was a government official. I handled tens of thousands of cases as the head of an agency. And I believe our people did things honorably, honestly, ethically, with integrity. We cared about getting it right. We cared about using the system to assist people get better from addiction and mental illness and things like that. And we also are proud of those people that we put away for as long as humanly possible because they represented continuing danger. But it's a human institution and people make mistakes. What that immunity is supposed to be doing there is that even if you can get past all those hurdles, is to say, you will chill people like Bob Bianchi or people that work for Bob Bianchi from wanting to be in that environment if every single innocent mistake that they make can be a civil rights case against them. What are your thoughts about all this?
Well, you raised some excellent points, Bob, as always. I look at this in two different ways. One, on the civil trial, or two, on the federal level. The state is going to bring, charges against someone. And if those charges are, defeated and the defendant wins the case, you might think, as our viewer has asked, that you can bring a malicious prosecution claim against the prosecutor. But to your point, there's protection in place. If the prosecutor is making a decision, they had probable cause to go ahead and bring that indictment against the individual, and whether or not, they acted in good faith, it is very difficult to bring a malicious prosecution charge against someone who is acting within their duties on the state level. I do think that on the federal level, when we're talking about civil rights, when we're talking about due process, or even the pattern in practice, I think those are a little bit easier for the prosecution to prove than on the state level for a malicious prosecution. And I say this because I believe that when someone's rights, their civil rights, their due process, equal rights, when that has been violated, the federal government can actually use evidence that goes beyond like what actually happened at that crime scene. So I do think that if you wanted to bring a charge and you wanted to say, look, my due process was violated here, I would do that over doing a malicious prosecution. But let me just end by saying this. Both of those are very difficult to prove. I mean, we've seen it in the past. You talked about George Floyd. We've seen some successes in some of the cases that we've been covering, but it's still very difficult to prevail.
All right, Terry, let me bounce it back to you because you kind of said this before. One of those things that I think you were talking about, criminal civil rights violations, which are different from civil rights violations. May be a better area to go, but in those cases, in the criminal one, they're allowed to bring in a lot of conduct that otherwise may be inadmissible in a normal trial. Just like RICO can bring in a lot of conduct and connect people who may not have known that a murder was going to be committed, may not have wanted a murder to be committed, but if you are part of the enterprise and the crime occurs, you can be held accountable. And the reason I ask this is that Slyte from YouTube asked this question: is this RICO dangerous for our democracy?
Well, it's an excellent question. I mean, it could be, as any law could be, if it's abused. I think if it is used as it is intended, it's not dangerous for the democracy. And if a prosecutor believes that there is criminal activity, that there is an enterprise, and that they are conspiring to commit crimes, I think they should be allowed to use RICO for that very purpose. And we're seeing it done more now than we have in the past. But if that's abused, and oftentimes the prosecution team is going to want to bring the RICO for the reasons you just stated, Bob, because you can get more evidence in when you're talking about a conspiracy. You can talk about those phone calls. You can talk about activities that may not even be illegal because it's all part and parcel of that conspiracy, of that RICO claim. So,
right, activities, phone calls, and conspiracies that you may not have had any participation or knowledge was even occurring. I think that that's a really great question. As a prosecutor, it certainly is a great tool, but you brought out something, Terry, that I think is really important. I said this as a prosecutor as well. Sometimes they give us more tools and they give us more laws, and you hope that prosecutors will use the rule of reason with regard to how they implement them. But many times I have noticed, even with my own colleagues, that they've gone and taken those laws, not for what they were intended to do, but using them in other environments, which I felt was inappropriate. That is really, really a great question. All right, we're going to take a quick break here. Don't go anywhere. Keep your questions coming. Love them. We're going to be back in a little while. All right, so we're breaking this case down here while we are awaiting the jury to come back from the lunch break, and they're really great questions. Paul, do you want to have any response to the RICO and your thoughts about that? And just to bounce off that, there's another question that we got. I want to try to find the person who gave it to us. I may have to look for it, but I'll give it at the end of your question. If they're successful, is Pandora's box now being opened in these kinds of prosecutions?
So I agree wholeheartedly with the answer Terry gave before the break. I think she's spot on because RICO is a tool. All these laws are tools, and tools can be used appropriately or inappropriately. I think most people will recall that RICO was really initially invented as a way to combat the mob in New York. That was the goal. It was too difficult to get the high-level people in the mob. They just kept getting all the low-level guys, and they would do time, and then they'd be replaced by more low-level guys, and they could never get the people at the top. RICO was a way to tie people into an organization and go after them. Now we've seen, I think RICO has kind of been abused over and over and over again. If you look at cases like what happened to R. Kelly, was what R. Kelly did horrible? Yes. Was it RICO? I mean, I think that was a bit of a stretch. We've seen this with so many different laws. We were just talking over the break, that tools start out addressing a specific need, but a lot of times prosecutors take these tools and they do start applying them to situations which the drafters of the law never intended, but which prosecutors can shove a round peg into a square hole and somehow make it fit. Does the circumstance technically fit under the legislation? Well, yes, even though it might never have been intended to. And so therefore, well, now we can use RICO. And I agree that most prosecutors, at least most prosecutors that I've met personally, are good and decent people who really want to do the right thing in all circumstances. But there are unscrupulous prosecutors, just like there are unscrupulous defense attorneys and doctors and cops in every industry that will use whatever tool at their disposal in a way that helps them get the goal that they want the most. And that's what we have to be skeptical of and on the lookout for. So, no, I don't think RICO is the end of democracy, but I think it can be dangerous.
Yeah, well, Shorts from Northwest from YouTube had asked that variation on that theme. And I'm going to go one step further, Paul, since you said it. I'm just curious. What I find are, yes, abuses of what the intention of the law was for. But I'm finding more and more there is a lack of training of lawyers and prosecutors in particular about a philosophy of justice. I mean, I found myself saying a lot of times as a prosecutor, just because you can doesn't mean you should. And that you have a tremendous amount of opportunity to bring people towards rehabilitation and mental health counseling. A lot of the people that we confronted were mentally ill and addicted and things of that nature. But I find that the younger prosecutors are not trained as well about what this sticky, maybe moving target of justice is. And if you're at least not thinking about what justice is, which is also mercy, compassion, and punishment and deterrence, then you're never going to get there because you're not even thinking about it. And it frustrates me as a defense lawyer now when you're trying to explain to somebody, we can make a positive difference here in someone's life, and here are the reasons why. And it's like bullets off Superman. They're just not listening.
Yeah, I started my career as a prosecutor in Brooklyn, and I was very fortunate that I had supervisors that really understood concepts of justice in the way that I think you probably conveyed them when you were training new ADAs, that just because you can do something doesn't mean you should. And justice doesn't mean pushing for maximum jail or prison time on every case, based on what the statute allows. There are times when justice looks like community service, when justice looks like, the minimum, when justice looks like dismissing the case under the circumstances. Justice comes in all manner of shapes and sizes, and it's not a one-size-fits-all thing depending on what the charge is. So I think that prosecutors really have an amazing amount of power and responsibility. And I agree with you that sometimes what we see with younger prosecutors is that they're so nervous about being viewed as weak in their own office that a lot of times they push for things that maybe they don't even necessarily agree with, just to make sure that they're not, underdoing it. And justice doesn't require that.
I've seen that, Terry, and that's because the boss is not letting them know that it is not weakness to come in and say that you think a just result can occur. Maybe it's the context of the crime, maybe it's the evidence in the case, and also failure to be able to appreciate the evidence in the case, the value of the case is another huge problem, and that's why they wind up losing cases. But in the end, the defendant is tortured for years going through that process. I got about 20 seconds thoughts.
You're reading my mind. That's exactly what I was going to say. You need to have bosses who say it's okay if you lose a case. It's okay if you have a case dismissed. It just means you have to, next time look at it a little bit differently and make sure you look at both sides of the argument.
I'll go to my man, Carmen Messana, who was my mentor, who told me there's plenty of cases, Bob. If we think we're doing the right thing here, don't worry about it. Our job is to do justice, not just get convictions. On that note, Terry, I want to thank you so much. We're going to take a break. We'll be right back. Welcome back to Law&Crime. This is our final hour of coverage. If you're just joining us, my name is Bob Bianchi. We're having a great time here because we're taking your questions during the lunch break for the RICO trial of rapper Young Thug. So let's make sure we get to the social media if you're there or YouTube to see whether or not you have any questions you want our great guests to answer. Now, this Grammy-winning artist, Young Thug, whose real name is Jeffery Williams, stands charged with racketeering activity and participation in a criminal street gang. Now, prosecutors allege that Thug and 5 other co-defendants are on trial for being a member of the gang YSL, which they say stands for Young Slime Life. Defense attorneys claim, no. YSL is nothing more than a record label. The indictment includes charges of theft and burglary, murder, conspiracy, and weapons possession. Prior to the start of the trial, a number of defendants took plea deals, including rapper Gunna. So let's start getting to some of these questions. We have a new guest. Paul Townsend is still with us, but we now have Aaron Reed with us. He's a criminal defense lawyer out from Arizona. Welcome to the show, Aaron. So one of the questions that now that we talked about Gunna is that Gunna took a plea in this case, and I was Hip Hop Press 365 out of YouTube who asked, when Gunna accepted his plea deal, does that mean he wrote a statement in addition to the video footage of him admitting that YSL is a gang and committed crimes? Paul, I'm going to go to this one for you first, because we kind of were talking about this a little bit before. Sometimes prosecutors have to put people on the witness stand that they may particularly not want to. But if they do use Gunna's plea and somewhat admission about with respect to a street gang, how powerful can that be? Because these defendants are close with one another.
It has the potential to be very powerful. So you have a number of people who are arrested in connection with the allegations that YSL is a street gang. And you have some people who already have, raised their hand, changed their plea to guilty, sworn under oath that, yes, YSL is a street gang and I am guilty of these charges that you have indicted me on. So if the prosecution can use that, if any of these guilty pleas came with the need for cooperation and potentially testimony against Jeffery Williams during his trial, then we may see some of these people who have pleaded guilty put on the stand and being forced to admit that YSL is a street gang. And that's going to be very impactful for the jury, because these are people on the inside. These are people who know the inner workings of this organization. And for them to come and testify under oath, yes, YSL is indeed a street gang, as they've admitted under oath, a jury is going to really get a reaction about that.
Yeah, and guys, this is like what we were saying before as a prosecutor evaluating that witness, because Gunna may not necessarily be the happiest guy getting on the witness stand testifying on behalf of the state. And if the jury gets that, and it may actually lend them more credibility when he's speaking. So it's not just, okay, yeah, can you attack them because you took a plea? Part of that plea was cooperation. Sure, that's the area the defense is going to go in cross-examination. But I've literally seen witnesses like this that get up there, clearly don't want to be up there, but the jury believes them at the end of the day. It really comes down to how they testify in front of the jury. Aaron, speaking of juries, we have a question here from Real with Robo from YouTube that asks another very practical question. Do you think all these breaks and coming back late affects or irritates the jury like it annoys us? Now, I got to push back on this question a little bit. I love that they're coming back late because it gives us time to answer these questions, but the point is well taken. We try so hard not to let that happen, but sometimes the jury's waiting and waiting and waiting in a small room, anticipating to come back at 12:30, and it's not 1:30, it's not 2 o'clock. How does that affect the jury? Does it upset them?
Absolutely, it upsets them. It's already a very lengthy trial process as it is. This case is very complex. There's a lot of moving parts. There's a lot of people involved, and that alone lends itself to needing court time. And when there's breaks and delays, The jury knows that they're not in there. They know that the case is not proceeding forward without them there. So in their mind, they're thinking that, yeah, this is taking forever. We're in this tight room. We're here every day. It's a difficult thing mentally. I don't think it really affects either side. It's just more of a demeanor of the jury. They're probably not going to be in the best mood during the trial, and I don't blame them.
Yeah, the judges try to do everything they can, right, Paul, to accommodate them and to let them know that there's reasons for that. But this really happens. I think it's more frustrating, Paul. You tell me. When you're in the middle of the trial and there's a constant back and forth with going to sidebar and constant objections. And that's why as a lawyer, you have to be very, very careful and strategic with any objection you make. Again, we talked about this before. Just because you can doesn't mean you should. Paul, have you ever had those lawyers that will object literally to every picayune reason in the world, and you kind of sit back and laugh because you're saying, you are just really making this jury hate you?
Absolutely. One of the first trials that I had as a prosecutor, I was up against a relatively inexperienced defense attorney who I guess had been instructed by her supervisor not to let anything go that, if you can't object, just stand up and object. And I had a police officer on the stand. I intended for his testimony to only take about 15 minutes. He really didn't have all that much to offer. He was not a critical witness in the case, but she objected to literally every single question. And it got to the point where I would just look over at the jury every time she did it, and they would roll their eyes. They were sighing. They couldn't believe it. These were not hard-hitting questions that were really getting to the core of whether or not the defendant was guilty. And the jury was just beside themselves. And the judge eventually called us both up and kind of very gently asked, if there was any way that we could move this along, and maybe some of these objections, were outside the bounds of the evidentiary rules. And she did calm down a little bit after that, but it's definitely something that impacts the jury, and it's a strategic decision to object. You need to make sure not only that you're right on the law.
CHEPAITIS.
Good afternoon, Mr. Titus.
Good afternoon.
Are you employed?
I am.
And where are you currently employed?
I'm employed with UL Research Institutes.
And have you had other employment prior to your employment with that institute?
I have.
Can you describe for the jury what that employment consisted of?
Yes. Prior to UL Research Institutes, I was employed by the Georgia Bureau of Investigation Crime Lab.
Okay. And how long did you enjoy your employment with the Georgia Bureau of Investigation?
It was about 7 years, give or take. A couple of different periods within that time.
Is the Georgia Bureau of Investigation also known as the GBI for short?
Yes.
I'll be referring to it for that way from now on. Okay. All right. And what did you do while you were at the GBI?
I was a forensic chemist.
And when did you begin your employment at the GBI?
In 2012.
Okay. And about when did you conclude your employment with the GBI?
So the first period I was employed by the GBI was from 2012 to 2016. At that point, I went to graduate school to pursue my master's, and after that, I returned to the GBI from beginning of 2019 to the end of 2021.
Okay. And where did you go for? Can you describe any undergraduate experience you have?
Yes, I have my Bachelor of Science in Biochemistry from Georgia Tech.
And you did indicate to the jury that you had a master's. Where did you go to get that?
Sure, my master's in chemistry from Georgia State University.
When did you complete your undergraduate degree?
My undergraduate was completed in 2012.
And when did you complete your master's?
In 2018.
Okay. And while you were working at the GBI as a forensic chemist, were you required to go through any specialized training?
Yes, I was. I completed their approximately 9-month-long training program.
Okay. And at the time, during the time that you were working at the GBI, were you in any way required to hold any certifications to do the work that you did?
We were not required to hold certification. However, I was certified as a fellow in drug analysis by the American Board of Criminalistics during my first period of employment there.
Okay. And are there any other professional associations that you are a part of?
Currently, I'm a member of the American Chemical Society.
And can you describe for the jury what
you enjoy being part of that professional association?
Sure. The American Chemical Society, or ACS, is just a professional organization for chemists. It's an international organization that provides access to conferences, training, networking opportunities, and things like that.
And how long have you enjoyed membership with that professional association?
For the ACS, it's been about 3 or 4 years, I believe.
And what is required to become a part of that association?
That is just a simple sign-up membership. That's it.
All right. And have you ever been admitted to testify as an expert in the area or field of forensic chemistry?
I have.
And about how many times would you say?
I'd say about 15 plus times.
Okay. And have you ever been qualified as an expert within Fulton County to testify?
Within Fulton County, I believe once or twice, yes, but I'm not sure.
Okay. And have you always testified in the area or field of forensic chemistry, given those testimony?
I have.
Okay. I'm going to transition here, Mr. Chivides. Can you describe for the jury what forensic chemistry is?
Sure. Forensic chemistry is basically the analysis of a substance to determine the presence or absence of a chemical of interest, a controlled substance. And so it's basically chemistry within the scope of the law.
Excuse me. And what kind of information can the results of the analysis performed by a forensic chemist give us?
It can tell us whether or not the item of evidence contains or does not contain a controlled substance.
And when you say controlled substance, can you identify for the jury what you mean?
Controlled substance being anything that's written in the law that's either illegal or in some other way controlled by a pharmacy or by some other entity.
Okay. And what kind of controlled substances did you test for during your time intervals at the GBI?
Sure. I tested for any number of controlled substances. I don't know. Would you like me to name a few?
Yes.
Sure. Cocaine, heroin, methamphetamine, marijuana. Those are just a few.
Did you have any other duties at the GBI other than testing for controlled substances?
No, I did not.
And have you, to be sure, have you personally had the opportunity to conduct testing analysis on controlled substances?
Yes, I have.
And would you be able to give the jury today a rough number about how many times you've performed such analysis?
I'd say well over 5,000 cases I've worked.
Okay. And what type of instruments did you utilize while at the GBI to conduct such analysis?
So we used a number of different scientific instruments and techniques to conduct the analyses. Would you like me to give a few examples? Sure. So we usually use a balance if we have to weigh a substance. So that's a pretty simple test. After that, we kind of split our tests up into what are called preliminary and confirmatory tests. The preliminary tests include things like thin layer chromatography, or TLC. They also include ultraviolet spectroscopy, or UV. And then some of the confirmatory tests that we do are kind of those techniques that give us a specific identification of a substance. So things like gas chromatography, mass spectrometry, otherwise known as GCMS, as well as infrared spectroscopy, or IR, FTIR.
Now, you just used some big words that are far greater than I'm able to understand. Can you, for the purposes of the jury, explain a little bit about what you're talking about when you use those words such as gas chromatology and infrared
spectroscopy. Sure. So the preliminary tests, like I mentioned, for TLC and UV. So UV, I can use that as an example. Ultraviolet spectroscopy. All that is basically shining a UV light on something, a solution, to kind of give me an idea of what may be in the sample. And those preliminary tests also, they also serve to separate the components of a mixture. So a lot of times substances that are received for testing are mixtures. We have to be able to separate those mixtures into their individual components. And after we separate those, we also have to identify them, and that's kind of the second part, the confirmation testing that we do.
Okay. And can you describe a little bit about that confirmation testing, that process or procedure that goes through?
Sure. So it's we'll say a more specialized kind of chemical technique is all it is, basically. It's something that's able to kind of literally break apart the molecules that are in the sample and give us an idea of what they are.
And after the molecules, to use your words, are broken apart, how are you then able to determine what they are?
Sure. So most of the tests that we do, most of those confirmatory tests and some of the preliminary ones as well, give us a graph. That's all it is. It's just a piece of data that we look at, and we can compare it to a known reference standard, for instance, and that helps us in our identification.
And when you say known reference sample, when you say known reference sample, what do you have in mind? What do you mean?
So if we're looking for a controlled substance such as cocaine or methamphetamine, we have a reference standard, so a pure sample of that substance that we can test at the exact same time and compare it to our results.
Is it fair to say that the known reference sample is the type of thing you're looking for?
Yeah, in a way, yes.
What are the possible results, types that you can obtain after you completed a round of testing?
What do you mean by that?
What are the results that you can receive?
So the results we receive are either we found a controlled substance or we haven't found a controlled substance.
And the type of testing that you have kind of been walking us through, is this the type of testing that is generally accepted within the scientific community?
It is. Yeah.
And do courts typically allow experts to testify about such subject matters for, say, a trial?
Yes.
Okay. And are there standards while you were at the GBI that controlled how the testing was performed within your particular division?
Yeah, so the GBI is what's known as an accredited agency. So you think about professional certifications, accreditations at any kind of job, and the GBI is no exception. The GBI has that accreditation, and that accreditation allows the GBI to follow a specific process for their testing, and that testing is governed. That accreditation is governed by an international body that sets down these regulations.
Okay. And those regulations that you're describing, that international body, did you follow them?
Yes.
Okay. And are there best practices associated with the type of testing that you did?
Yeah, those best practices would fall under that accreditation. Yeah.
And is forensic testing within the chemistry background something that an average person can do without any specialized training?
No.
Okay. Your Honor, at this time, the state moves to qualify Mr. Patrick Chapitis as an expert in the scientific field of forensic chemistry.
Anybody wish to voir dire Mr. Chapitis? Anyone? All right. And the court will designate Mr. Chapitis as an expert in the area, or qualify him as an expert in the area of forensic chemistry.
Okay. At this time, Mr. Chapitis, I want to ask you, did the laboratory, the GBI, receive any evidence pertinent to the reason for which you're here?
Yes.
And what evidence did the laboratory receive pertinent to this case?
Well, if I could see it, I would, or if I could see a copy of my report, I would tell you, sure.
Just a brief moment, Your Honor, I should have asked, may I approach? Thank you, Your Honor. Now approaching you with what has been admitted in evidence and pre-marked as State's Exhibit 78J. Mr. Chapitis, what have I handed you?
So what I received to test in this case would be 1 bag of solid material.
Okay. And from what you are looking at, can you identify when the laboratory received the evidence?
When the laboratory received it, no, I can tell you exactly when I received it.
When did you receive it?
It would be February 17th, 2020.
Okay. And after you received that particular piece of evidence that's already been admitted, can you tell the jury what you did with it?
Yes. So first I verified all the information on the package, and the way we usually do that is by, when it's received to the laboratory, the evidence receiving technicians would take pictures of it and give it a unique GBI case number here, as you can see on this barcoded label on both sides. I would first compare the pictures, make sure that the barcoded sticker has the case number that matches what I'm seeing in front of me. And then I would open it up, and then begin my analysis, and that would typically begin, and in this case it began with weighing the substance.
And the material that I handed you, to be sure, is in fact what you tested when you were at the GBI?
It is the sample I received and took a sample of to test, yes.
What color is the material that you have in front of you?
It looks to be white to me.
And can you describe the texture or feel of that particular evidence?
It just looks like it's a block of substance.
Is it solid material?
It is, yeah, solid material.
And can you describe for the jury where you received that evidence from?
Where I received it from was the Atlanta Police Department.
Was there a case number associated with it from the Atlanta Police Department?
The Atlanta Police case, according to the label, is 2002-11823.
And for this particular piece of evidence that you performed an analysis of, can you describe what that analysis consisted of?
Yes, so like I mentioned a little bit ago, was that first I weighed the substance, and all that is I took a net weight, which means I took the entire sample out of the packaging and weighed it on a balance. And once I had that information, I could continue on with my testing. The first test I did was one of those preliminary tests. In this case, it was thin layer chromatography, or TLC. And all that is a separation technique where I take a little, excuse me, I take a little bit of the substance, dissolve it in a liquid, and I have a glass plate with a film on it, and I basically spot a drop of the sample solution on that, and that's able to separate out all those components in the mixture that I talked about earlier. And at the exact same time, I spotted a solution of reference standard as well. And then at that point, I was ready, after forming some preliminary conclusions about what may be in the sample, I moved on to one of those confirmatory tests. In this case, GCMS, or gas chromatography mass spectrometry. And all that is, the first part, GC, is the part that separates, again, the components in the mixture. And once those components were separated, it moved on to the MS, or the mass spec portion of that test. And the mass spec is what gives me that graph that I can compare to my reference standard and say, hey, this is what I have in the substance.
At the end of all of that analysis that you performed there, did you reach a conclusion?
I did.
And what was the conclusion?
My analysis confirmed the presence of cocaine in the sample tested.
And was your analysis subject to peer review?
It was.
And is that commonplace at the GBI?
Yes, every case that gets called into court is peer reviewed.
And with respect to testing, is there a known error rate or anything associated?
In this case, since the substance was not, we didn't get a quantitative result on it. All I did was get a weight. The only thing that would be subject to that would be the weight of the substance.
And what was the weight if you could?
The weight was less than 1 gram.
Okay, and with with respect to the analysis that you performed on this particular test, on this particular solid material, did you follow the standards and protocols that you outlined for the jury earlier during our conversation?
I did.
And Mr. Jeffery, after you performed the analysis within the lab that you described, what else, if anything, do you do?
After I perform the analysis, I would generate a report to state my results.
Okay. Now showing you what has been pre-marked as State's Exhibit 88J and has already been previously served with this defense counsel in discovery. Your Honor, may I approach the witness?
You may, sir.
Mr. Chapitas, what have I just handed you?
My report for this case.
And how do you know that that's your report?
It has my GBI case number on it that matches what's on the evidence, and it also has my name and signature on it.
And has that report that I've handed you been altered in any way, form, or fashion since the time that you authored it?
No, it has not.
And Your Honor, at this time, the state now moves to admit State's 88J.
Any objection?
Yes, sir.
Any objection to State's 88J?
Yes, sir. I'll object under the Confrontation Clause that was made for testimonial purposes, Your Honor, and if the court does admit it, I would object under the continuing witness rule.
I'll deal with the issue second later. As to the first basis for your objection, I'm going to overrule that, and I'll admit it over your objection to State's 88J. Nick.
Okay. Mr. Chapitas, on that report that you have in front of you, is there a particular name by whom, was this testing requested by anyone?
It was requested by the Atlanta Police Department.
Okay. Does your report include a name from anyone from the Atlanta Police Department?
Yes, it says S. Stansel.
Okay. And is there a person associated with as a subject for whom that substance was known?
Yes, Durante Beebe.
And the substance that you tested, did you conclude on your report a drug, where it fell on the drug schedule?
Yes, it fell under Schedule 2.
And at this time, Your Honor, the state now passes this witness to the defense for any further cross.
All right. Cross? Anyone?
None on behalf of the state.
Anybody else? Okay. State have anything further?
Not for this witness.
All right. May we permanently or temporarily excuse?
You may permanently, Your Honor. Excuse Mr. Chavitis.
Mr. Chavitis. Sir, I'm going to go ahead and permanently excuse you as a witness. Thank you for your patience with us. Don't discuss your testimony with anybody except the attorneys in this case, okay?
All right.
All right, thank you, sir.
Thanks, Tom.
Your Honor, I am approaching the witness stand to retrieve the admitted evidence, and at this time, the state.
Before you move on, you just identified State 78A. You haven't tendered it, is that correct?
It was admitted, should have been.
Who is it admitted by?
Just a brief one, Your Honor. It should have been admitted by way of Officer Stantz.
It was 78J?
Yes, sir.
What was it, 78A?
70, maybe phonetically it may have gotten lost in translation. It should be 78J.
Okay, all right, well then we're good. Okay, all right.
All right, Your Honor. At this time, the state now
Well, Your Honor, are you ready to hear?
Your Honor. Yes, Mr. Sharp.
Your Honor, if the state is to admit the self-authenticating documents, I would ask to be able to see the documents before they're announced what they are for the jury.
Okay, just generally, I think they're supposed to do that.
Specifically this one, because I think that there's
He hasn't identified it for the record yet, so.
Your Honor, if he identifies that,
Now, just, what is it you want to tell me?
if he identifies it, it's going to be too late for me to.
What document are you referring to, sir? Oh,
I have to see it.
all right, well, come up and have a look at it then.
Your Honor, if I may, defense counsel has had the opportunity prior.
Well, let him look at it again, just to make sure he's satisfied
Read
that.
everything. I just want to know what's in your head. Okay. Thank you, sir. Thank you.
We good? Mr. Sharp?
Mr. Weinstein. I'll let, is he sought to admit it?
No, I don't know what because you interrupted. He hadn't finished when I was talking, and you interrupted him, so let me just kind of see what's on the table.
Yes, sir.
All right. Yes.
Yes, Your Honor. Your Honor, at this time, pursuant to Rule 24.901 of the Georgia Code, the state now moves to admit Exhibit 83J into evidence, which is a certified conviction for Mr. Durante Beebe. And if the court should like to see it, I can provide that at this time.
Your Honor.
And what does that state what?
States Exhibit 83J, as in Jacob.
All right, sir.
Yes, the continuing objection.
Yes, it'll be.
Case.
I noted it.
Your Honor, I would ask, beyond that objection, there are some extraneous documents being presented that go beyond the certified conviction. So it would be a objection to the introduction of the extraneous documents.
Can I see it?
Yes, Your Honor. May I approach?
Yes. right, Mr. Short and Mr. Brown, come on up. All right, it's Talk Radio. You don't need to press that button at all. Just talking to the microphone. Okay. What is that?
Thank you. Your Honor, I've just now been handed back State's Exhibit 83J as in Jacob, and pursuant to the court's permission to publish, I will now do so for the jury. Yes, Your Honor. Yes, Your Honor. Yes, Your Honor. In front of me is a certified conviction for Mr. Durante Beebe in the case of State of Georgia versus Durante Xavier Beebe in the criminal action number of 20 SC 174500. This plea was entered as a non-negotiated plea to the charge of possession of cocaine. The disposition was guilty, and at this time, Your Honor, this particular charge pertains to the incident occurring on January 21st, 2020.
Nothing speaks for itself.
I will continue. The charge pertains to the incident in the indictment, in the accusation pertaining to the incident occurring on January 21st, 2020, wherein which he was charged with unlawfully possessing and in control of cocaine, a Schedule II substance in violation of the Georgia Controlled Substances Act. And at this time, Your Honor, I will proceed to read the sentence that was given by Judge Melanie Lethbridge. According to the document, it states that the defendant is sentenced to a total of 3 years probation with conditions. Your Honor, those conditions are, the state will forego reading those. Yes, Your Honor.
All right. Okay.
I've got an additional objection to this being admitted with reference to Mr. Nichols. There's a standing, I guess, a continuing objection under the Jefferson case, but also, Your Honor, I would object it going into evidence under 24.
Okay, is this for later or for?
For now.
For now?
For now. I am objecting to this going.
Can you come up to the bench, please?
Sure.
All right. Just talking. You don't have to press anything. Just talk into the microphone. Okay. Yeah. Just pick it up. Yeah. Talking to. All right. We'll see. But hold on 1 second. That was 10 minutes yesterday.
I don't hear. I don't hear. Did you say something that you want to reference? Or are you still talking? Because I'm not taking anything down. You don't listen to me. Yes. I can't hear you.
Can I come tell you something?
You need to speak up if you want to understand.
All right, sir. Are you prepared to call your next witness?
Hey, Ron, while the next witness is coming, can I approach with one of the members of the defense?
Yes, you may.
Some information I just learned.
Can't hear you? Yes.
Okay, before we call our next witness, members of the media, this particular witness, I'm going to ask that you not film just this witness, okay? Thank you. You can still do audio and any other things, but it was brought to my attention, given the work this person does, that we probably shouldn't video them at this time. Okay? All right. Okay, call your next witness.
Your Honor, State Cause Officer Applewhite.
All right, Officer Applewhite, summon him, please. All right, Officer Applewhite, sir, if you could please approach the witness stand. Once you get there, if you'd be so kind to turn and face Sergeant Ingram, be sworn as witness before you sit down.
You swear to affirm the testimony you give the truth, the whole truth, and nothing but the truth?
I do.
Have a seat. State, spell your first and last name.
Ian Applewhite, IANAPPLEWHAITE.
Good afternoon, sir.
How you doing?
Good, good. Sir, where are you presently employed?
Atlanta Police Department.
And in what year did you start with APD?
I started in June of 2016. I got sworn in 2017, January.
Okay. And what unit were you assigned to when you started with APD?
Zone 4 Evening Watch.
And how long were you in that unit?
Approximately 2.5 years almost.
And what was your responsibilities in the Zone 4?
I was a beat officer. I was assigned to 403's beat. Just patrol, answer 911 calls. If I do have downtime, I do proactive work.
Okay. And for your entire time with Zone 4, were you always assigned to Zone 4?
No, well, I was also part of the Zone 4 fit team. Then I went to the gangs unit as a gang enforcement officer, then auto crimes enforcement officer, and now in Zone 2.
Okay. So what years or what months were you in the gang unit?
I want to say it was April of 2021 to January 2022, something around there.
Okay. And you also mentioned the auto crimes unit.
Yes.
What years were you in the auto crimes unit?
Started February of 2022 until, I'm confusing myself right now. February of this year, sorry, till September.
Till September of this year?
Yes.
Okay. And September of this year, what unit are you assigned to?
Zone 2.
And what are your responsibilities in Zone 2?
Answer 911 calls, during my downtime, do proactive work.
On or about May 9th, 2020, what unit were you assigned to?
Zone 415.
And were you post-certified on May 9th, 2020?
Yes, sir.
Now, what is proactive work?
So if depending, the calls for services are low, you usually will go out, try to conduct a traffic stop, or you might want to go to a high drug area and try to get, some drugs or something like that.
You mentioned high drug area. Are you familiar with high drug areas based on your, will you tell the jury, in what unit did you become more familiar with the?
With the Zone 415.
Are you familiar with 151 Cleveland Avenue?
Yes.
How are you familiar with it?
I did an undercover buy at that location.
And why did you do an undercover buy?
The Zone 315, they were conducting a detail, and they asked for the Zone 415 assistance. My role was to do an undercover buy at different locations within Zone 3.
About how many undercover buys do you typically?
So it depends. I mean, if we get a lot of people, maybe that's it for today. If we get one or two, then we can probably move to the next location.
On May 9th, 2020, did you have a reason to visit 151 Cleveland Avenue?
Yes, sir.
Why? Tell me why did you visit 151 Cleveland?
So again, Zone 3 was conducting a detail. This is one of their high crime areas. And they wanted to do a little, and try to put an impact on the drug sales in that particular area along the Cleveland corridor. So they asked me to go undercover, try to buy some drugs. So I was pointed to that direct location by one of the Zone 3 officers, said there might be something going on in there. So I walked in. As I walked in, there was a male who was wearing white pants, white shoes, with a blue jeans jacket. He was standing somewhat in the doorway. I walked in, and I just asked him, "Hey man, you got some smokes?" He said, "Yeah." He said, "How much you want?" I said, "I got a 20. He reached in his pocket, pulled some weed out, wrapped it up into a lottery ticket. I paid him the 20. He said, "Hey man, here's my phone number." I got his phone number, and I left. Once I got back into my car, I left the location to update the takedown units of the sale, give them a description of the mill that I bought the weed from, and just proceed to the next location.
Okay. So based on your experience at Zone 4, your time in the gang unit, time at auto crimes unit, and your current assignment at Zone 2, is in your opinion, is 151 Cleveland Avenue a known gang area or high crime area?
Yes, sir.
Now, you made reference to a transaction at 151 Cleveland Avenue. Can you kind of walk me through that transaction?
Okay, so I pulled my undercover vehicle up at the pumps. At the same time, I do have close cover who are
somewhat in the area just in case something goes wrong. I exited the vehicle, I walked into the store. Again, he was somewhat in the doorway. I walked in, I approached him, hey man, you got some smokes? He said, yeah. He said, what you want? I said, I got 20. I gave him the 20. He rolled up some marijuana, dropped it into a lottery ticket, one of those things you find at the counter, rolled it up, I handed him the money. As I was about to walk off, he said, hey, big bro, here's my phone number. I took his phone number.
I'll overrule the objection.
Officer Applewhite, in what capacity were you working on May 9th, 2020?
Undercover.
And how many undercovers had you, how many times had you gone undercover before?
That actually was...
I'm sorry, who said that?
Is that Mr. Adams? I'm going to overrule the objection. I'll sustain the objection, I should say.
Who did you come in contact with on May 9th, 2020?
I think it's John Travis. I'm sorry, hold on. DeAndre BB. Yeah, DeAndre BB.
And what was the location of the sale?
151 Cleveland Avenue.
Okay, and what was that? Was that in
Fulton County? It's in Fulton County, yes.
What did Mr. BB sell you?
Marijuana, or suspected marijuana.
Did you tell Mr. BB that you were an officer?
No, sir.
What did you do after you purchased the marijuana from Mr. BB?
I immediately left the location and relayed the information to the takedown units. One of the close coverage from Zone 3, he met up with me, I believe it was at the Walmart on Cleveland Avenue, and I gave him what I bought. And then I went to the next location or to Zone 3 to to write my supplement report.
Zone 3.
To write a supplement report.
Did you clearly describe Mr. BB to the other officer?
Yes, sir.
And what was that description?
Black male, white pants, white shoes, blue jeans jacket.
Did other officers respond to the scene?
Yes, the Zone 3 fit and Zone 4 fit team.
About how many details have you participated in with Zone 3?
I'll overrule the objection, Mr. Steele.
A lot. About over 4.
Okay, and what do those details consist of?
High crime area. Sometimes we do details for stolen vehicles, warrants, or drug area.
When other officers responded to the scene, were you still present on scene?
No, sir, I was gone.
And did that basically complete your investigation with this matter?
Yes, sir.
That's the witness, Your Honor.
Cross. Mr. Sharp. Oh, Mr. Adams.
Applewhite or Applewhite?
Applewhite.
Wait.
Yes, sir.
Like A. Okay. Good afternoon, sir.
Good afternoon.
Got just a couple of questions for you in regards to what you just testified about, okay? And if you don't hear me, if you don't understand my question, please get my attention, let me know. I'll be happy to repeat. Okay? All right. So this is May of 2020 that we're talking about in this case, right?
Correct.
All right. This incident happened back then, and then you were part of the Zone 4 fit team. Did I get that right?
Correct.
Okay. You were working in what is called an undercover capacity.
Correct.
Now, you used some terms earlier that I want to talk to you about. You talked, for example, about high crime area.
Correct.
Right? Zone 4 is a particular portion of the city of Atlanta, right?
Correct.
There are many different zones in the city of Atlanta.
Correct.
There are very many high crime areas in the city of Atlanta.
Correct.
Zone 4 ain't the only high crime area in Atlanta, right?
Correct.
Right, so although we're talking right now about an area that someone says is a high crime area, you can go to areas of Buckhead, Atlantic Station, where there's a lot of, where there are drugs being sold, right?
Correct.
You talked also about a high drug area, right?
Correct.
There are a lot of high drug areas in the city of Atlanta, aren't there? Right, it's not just Cleveland Avenue.
Right.
Right? It would be incorrect to say that the only place there are drugs sold or where there's crime that takes place is Cleveland Avenue. That wouldn't be accurate, right?
Correct.
Right. In fact, if as a police department or a police officer you chose to target a high crime area and you wanted to go into somewhere in Buckhead, you could find a high crime area in Buckhead to target, right?
Correct.
To do undercover buys at, right? Mm-hmm. To find people who sell weed, correct?
Correct.
On this day, you went, you didn't go on your own. You were told by, I presume, correct me if I'm wrong, other members of the FIT team about this particular location. Correct. Right?
Correct.
Right. I mean, they could have sent you anywhere else. As a matter of fact, if I heard correctly, you said that there are a couple different areas that you would go to. You'd maybe hit one area, right? And depending on, I'm sorry, I keep taking glasses on and off. I got to see. Let's see. If we get a lot of people, then you move on, you go to another area.
No, so if I have, let's say we arrested 10 people, that's a day's work right there.
That's a good day.
It's a day's work.
Okay.
It takes a long time to process the evidence, you know, the warrants, the transportation. So again, if I get one person, then we'll move to the next location.
Go to somebody else.
Another location. I don't, you know.
Hey, you got a number of people. I mean, you said there's one person versus 10 people.
Right, gotcha.
One person, you got more work to do.
Right.
10 people, I'm done for the day.
Right.
Okay. You ever heard the term weed man?
Say it?
Weed man.
Weed man?
Yeah. I mean, you know how sometimes folks, I don't know, college kids, regular kids, adults, young folks go looking for the weed man to go buy some weed?
Oh, okay, yeah.
Right? You heard that term before.
I've heard.
There is such a thing called a weed man, right?
Yes.
Okay. Sometimes it's one man. Sometimes it could be a woman. It could be a weed woman, right?
Correct.
Okay. When you got to, what's the address? 151 Cleveland Avenue. You're there to do the undercover buy, right?
Yes.
You are dressed in an undercover capacity. You look like a regular dude.
Right.
And you encounter this guy that you referenced earlier who is in white clothing, I think you said, right?
Correct.
You walk in, and you approach him, and you ask him if you got anything.
Right.
You were looking to buy some weed.
Correct.
And lo and behold, you bucked up on the weed man, and you got $20 worth of weed, right?
Correct.
Okay. And I think I heard you say that, and then this was a young, his name was BB.
Right.
I think you said Durante, something like that?
Durante, yes.
Okay. He gives you $20 worth of weed in a, what'd you say, a lottery ticket or something?
Yeah.
Okay. So you get your $20 worth of weed from the weed man, and you're out of there. Okay. Was he by himself?
Oh, no, they had maybe one or two other people in the store with him.
Okay. All right. But what has just taken place is you just bought $20 of weed from this kid, right?
Correct.
Okay. And that appears to be the long and short of it. You left out of there. Your job for the day, at least at that point, that location was done.
Correct.
$20 weed sale.
Right.
Okay. And then you left and you told the takedown unit. Did I get that right? Is that the name of it?
That's correct.
Okay. They're the folks that you would call and say, hey, I just bought $20 worth of weed. Come and get the guy.
Correct.
And you weren't there, but presumably they went to go get the guy.
Correct.
Okay. There wasn't anything else going on at the location when you pulled up, right?
No.
No, nothing else, just some kid who you asked for and got $20 of weed from.
All right.
Thank you, sir.
You're welcome.
That's all.
Any further cross? All right. Mr. Sharp?
Yes, Your Honor.
Good afternoon, sir.
Good afternoon, how you doing?
I'm doing great. How are you?
I'm all right.
Just a couple questions.
Okay.
Mr. Beebe, first of all, did you see him in court today?
No, let me see. I can't really tell now.
Okay. And Mr. Beebe, on that day that you encountered him in the gas station, he was wearing white shoes, white pants, and a blue jean jacket, correct?
Correct.
Is there any other clothing description that you recall?
That's what I saw, and that's what I gave out, yes, sir.
Thank you. Nothing else.
All right, anybody else have any cross? All right. Any redirect from the state?
Just briefly, Your Honor. Officer Applewhite?
Yes, sir.
Are you looking for crime or targeting people?
Crime?
And why are you targeting high crime areas?
Because that's where most of our incidents occur, shootings, drugs, a lot of the, community members, they complain a lot. I'm speaking for Zone 4, and that's why we're in the area doing what we're doing.
And were you looking for weed for yourself?
No, sir.
Was this for purposes of targeting high crime areas?
Correct.
No further question.
Anything further?
You weren't targeting on this day shootouts or killings or anything like that. You were targeting a weed sale, right?
Again, the detail was a Zone 3 detail. All I know was to do was to go buy some drugs, not necessarily weed, maybe crack, some pills, depend. But at that particular time, that's what I was going for.
Your assignment, your focus at that time, at that location on Cleveland Avenue, was to go buy some weed.
Some drugs, yes, sir.
All right, thank you.
Anything further? All right, at this point in time, may Officer Applewhite be permanently or temporarily excused as a witness?
Permanently, Your Honor.
All right, Officer Applewhite, thank you for your patience with us. I'm going to permanently excuse you as a witness. But don't discuss your testimony with anybody except the attorneys in this case, okay?
Yes, sir. Thank you.
Thank you, sir. All right, State, call your next witness, please.
Yes, Your Honor. The state calls Officer Jeffery Hawkins.
All right, summon Officer Hawkins, please. Are we good with this witness not being, we okay? All right, you can film. Yes, thank you. All right, Officer Hawkins, good afternoon. Madam, come on up. If you please approach the witness stand. Once you get there, ma'am, raise your right hand for me, please. Do you solemnly swear or affirm the evidence you'll give in the matter now and hearing should be the truth, the whole truth, and nothing but the truth? You are so affirm?
I swear.
Okay, you can please be seated. All right, madam, if you could state and spell your first and last name for the record, please.
Yes, my first name is Jasmine, Jasmyn. Last name, formerly Hawkins, Hawkins. Currently Mogavero, Mogavero.
And what name was your phone?
Mogavero is fine.
Okay. Okay, which last name? Oh, okay. Officer Mogavero, where are you currently employed?
City of Atlanta Police Department.
And how long have you been with the City of Atlanta Police Department?
Since August of 2017.
And what is your current assignment?
The larceny from auto unit.
And how long have you been with that larceny unit?
From February of 2023.
If you can tell the jury briefly about your history with the Atlanta Police Department, starting with your assignment after the academy.
Okay, so I've been sworn since March of 2018. June, I was assigned to Zone 3 Morning Watch. I worked there until February of 2020. At that time, I was assigned to the Zone 3 Crime Suppression Unit. And then I stayed there until August of 2022. And then I went to Zone 3 Day Watch for a few months until coming here.
So it's safe to say a good majority of your career so far has been in Zone.
Correct.
All right. And are you post-certified?
I am.
And were you post-certified in May of 2020?
Yes, I was.
I want to take you to May 9, 2020. What unit were you assigned with APD?
The Zone 3 Crime Suppression Unit.
And what were your job duties and responsibilities working with the Zone 3 Crime Suppression Unit?
It's a proactive patrol unit, so conducting traffic stops, stops on suspicious persons in the community, or whatever other directive we had for that day. Usually proactive policing.
And you also said you served as a patrol officer within that community.
Correct.
As a patrol officer and also worked with the crime suppression unit, were you familiar with 151 Cleveland Avenue?
Correct, yes.
How are you familiar with 151 Cleveland Avenue?
I've answered a number of 911 calls there. I've completed traffic stops where people have pulled into that gas station, directed patrols, going inside speaking with the clerks at the gas station as well.
Why are there directed patrols at that location?
151 Cleveland Avenue, it's part of it's high crime at that location and in that general area.
And when we say high crime, what are we referencing?
Shootings, drugs.
I'm going to show you what's already been admitted as State's Exhibit 78J. It should show the screen. Excuse me, 79J. And looking at 79J, where is 79J?
This is from the front of this gas station, 151 Cleveland Avenue Southwest.
And is that what you were just referencing as a high crime area?
Correct.
Now, when you go out to patrol or do target patrol, why are you going to that? What brings you to that area to target patrol?
Just due to the nature of crimes that happen at that gas station, at that intersection, Cleveland Avenue, Old Hapeville, supervisors and probably coming from the top down, they want to make sure those areas stay safe, so they ask us to spend some extra time there.
And in your experience, are you getting any calls from community members about that location at 151
Yes.
Cleveland Avenue?
Yes, absolutely.
So in your experience, the community is concerned about what happens at there?
I sustain this to form.
In your experience, is the community concerned about what happens at that location?
Yes.
Same objection, Judge.
I'll sustain this to form. You can rephrase it.
Have you ever seen concerns about that location from the community?
Yes.
We're going to object on the grounds that
I hear Mr. Harvey mumbling in the background. If there's an objection, please state it.
An objection would be hearsay.
Okay, overruled, and your objection, Mr. Matthews, is overruled as well.
All right. I want to direct your attention to May 9th, 2020. Did you have the occasion to respond to 151 Cleveland Avenue?
Yes.
Why did you respond to that location?
We were in the location, there was an undercover officer at that location looking for drug activity at that gas station.
And do you recall what time of day did you respond to that location?
So that would have been about 9:46 at night.
I see you open up an envelope. Is that your police report?
It is.
Okay. We're looking at a copy of your police report. Have a refresher memory as to what time you responded. I'm going to show you what it gives you. Commissioner Approach, Your Honor.
You may.
I'm going to show you what's been marked as State's Exhibit 108R. Tell me if you recognize Exhibit 108R, and you can flip it.
I do, yes.
Okay, and how do you recognize Exhibit 108R?
This is the narrative portion of my incident report.
Okay, and we're looking at State's Exhibit 108R, help refresh your memory of what time you arrived at that location.
Yes.
Okay, you can go ahead and just read it to yourself, and once your memory's refreshed, you can look at it.
Okay. I'm all set.
Okay, what time did you go to that location?
At 9:46 p.m.
All right. And what happened once you arrived at that location?
We received word from the undercover officer at the location that he was just sold 1 gram of marijuana inside the gas station. And then at that time, he gave the description of a black male wearing a jean jacket, white pants, white shoes, who sold him that marijuana.
Once you had that description, what did you all do?
All of the units that were there that day pulled into the gas station. There were numerous other people at the gas station as well, but that was the main focus at first. And then when I approached, I got out of the vehicle. Other units had already got out of their vehicles and were in the process of detaining that male.
Okay, so let's slow down. You said there were a number of different locations going on in it. What do you mean?
So I can't give the exact number of officers that were there that day, but there were other vehicles that were associated with the vehicle that Mr. Beebe was in, and that they were seen interacting with him as well prior to our arrival.
Those other people were seen interacting with Mr. Beebe?
Correct.
All right. And what kind of car was Mr. Beebe?
He was in a white 2020 Honda Accord.
Now, were you all able to detain Mr. Beebe?
He was detained, correct.
Okay. Where was he seated when you all first interacted with Mr. Beebe?
He was in the passenger seat, front passenger seat.
And if you just said, I apologize, but what kind of car was he in?
A white 2020 Honda Accord.
Okay. And once Mr. Beebe was detained, what happens next?
He was detained, and then at that point I started my search of the vehicle.
Okay. And what, if anything, was found when you did your search?
So there was 13 grams of marijuana in a clear baggie that was found inside the vehicle, the passenger seat, as well as a marked $20 bill that the undercover officer initially had, and that was used during that sale of that 1 gram of marijuana.
Okay. Was there anything else recovered?
From inside the vehicle, yes. There was a small backpack, a multicolored backpack. It was on the center console, front center console, and there was additional marijuana found inside that backpack.
Okay. And who did that backpack belong to?
That was Miss Chastity Williams.
Okay. Once you found the marijuana inside the car, did you arrest Mr. Beebe?
I didn't place him under arrest. He already was detained, but at that point, the marijuana on the seat was determined to be his.
Okay. And was there anything else recovered from Mr. Beebe?
There was also a firearm recovered from him.
And was it recovered from his person?
Yes.
And that firearm that was recovered, was that firearm ran? Was it run? Did you
Yes.
run it? Did you run
Yes, it was.
And what happened once you ran the firearm?
It was.
Foundation, Your Honor. Also saying this, just let me just rephrase it now.
Sure. Did you recover a firearm?
I didn't personally recover it, but it was recovered on scene, yes.
Okay. And when that firearm was recovered, did you run, was the serial number run?
Objections Foundation to who ran it?
I sustain objection.
Do you know who ran the firearm?
I ran the firearm.
You ran the firearm, okay. And when you ran the firearm, what happened?
The firearm came back as stolen.
And did you ultimately collect that firearm?
It was collected, yes.
Okay. And what about the marijuana?
The marijuana was also collected as well.
Did you... Permission to approach, Your Honor?
Yes, you may.
I'm going to first show you what's been marked as State's Exhibit 90K, 89K, and 90K. Tell me if you first recognize State's Exhibit 89 and 90K.
Yes, 89K I recognize.
Okay, how do you first recognize 89K?
This is the 1 gram of marijuana that was sold to the undercover officer.
All right. And what about 90K?
This is the remaining marijuana that was recovered from inside the vehicle.
Okay. And was that recovered again? Where was that recovered again from inside the vehicle?
On the passenger seat.
And where was Mr. Beebe sitting at?
He was in the passenger seat.
All right. And does that appear to be, based upon looking at the bag, what you collected back in May of 2020?
Correct.
You're right, this time say like the tender states exhibit 89K and 90K into evidence.
Any objection to 89 or 90K?
No objection.
All right. 89 and 90K are admitted, may be published as you see fit.
Mr. Adams, do you want to look at the firearm?
Sure.
I'm now going to show you what's going to mark as 91K.
Okay.
You can look at it, tell me if you recognize 91.
I do.
Okay, and how do you recognize 91K?
This is the firearm that was turned in, that was on Mr. Beebe's person, and the serial number matches as well.
Okay, does that appear to be the gun that was recovered off of Mr. Beebe back in May of 2020?
It does.
All right, Your Honor, this time say like the tender states that the 91K into evidence.
Any objection?
Objection.
All right, states 91K is admitted and may be published as you see fit.
Thank you, Your Honor. Once you collected the evidence and turned it into property, did that conclude your involvement in this case?
It did.
All right, I have no further questions.
Cross. Go ahead, Mr. Adams, whenever you're ready.
Good afternoon, ma'am.
Good afternoon.
Rank, please.
Investigator.
Investigator, thank you. And you'll excuse me, I heard your name earlier. I heard you say Hawkins, but I think you said it's changed, right?
Correct. It's Magavaro.
Magavaro?
Correct.
All right, thank you. Investigator Magavaro.
Correct.
All right, so just a couple questions, if you don't mind, about this incident back in, and I keep hearing May the 9th, but it was actually May the 8th, wasn't it?
Correct.
Okay. All right, so if I heard correctly, you responded because there was an undercover sale that had been made at that location, right?
Correct.
You advised that there was a $20 marijuana sale that had been made. I don't know if you knew at the time the name of the person was Bibi, but you had a description of the individual.
Correct.
Right? And when you got to the location, you saw someone fitting that description, jean jacket, white pants, and that person was in a vehicle.
When I saw him, he was no longer inside the vehicle.
Okay. So the first time that you get to the location, he's already been detained or taken into custody or whatever by other police officers.
Correct. They were actively detaining him.
Okay. And they found, let me see, the item that you were just asked to identify a little while ago that I think is over here now. So you identified two things. One of them was the 1 gram of marijuana that was sold to the undercover officer. That's this one, right?
Correct.
And then there was some marijuana found in the car that Mr. Beebe was supposed to have been in.
On the passenger seat, correct.
On the passenger seat.
Mm-hmm.
But he wasn't in the car when you pull up, right?
Correct.
Okay. You just know that you were told that there was some additional marijuana found on the passenger seat in the vehicle that he supposedly was in before you got there.
Correct.
Right. And what, 14 grams of marijuana?
Correct.
This right here?
Correct.
Okay. And $20, was it $20 that $20, that the undercover officer had used to buy this 1 gram of marijuana, right?
Correct.
Okay. Started off, and it was a gun that was found there for this gentleman, Mr. Beebe. It was found on him or in the car where he was supposed to be.
On him.
Okay. This white Honda Accord was determined to have been owned by a young lady, or a lady, I'm not sure if she was young or not, Jeffery Williams, right?
Correct.
She was detained, and I think, was there some marijuana found on her as well?
It was not found on her person. It was inside of a backpack that she advised was hers.
Okay. And there were some other people there at the location that the police had detained and searched and, I guess, found some marijuana on also?
Correct.
Okay, so it sounds like everybody there, whoever happened to be there at the gas station at the time, was either stopped, or if they were coming into the gas station, was stopped and detained and searched, right?
Yes.
Okay. All right.
Well, sorry, not everybody. There were people that were not detained there as well.
At least 6 folks, right?
Yes.
Okay. Ranging in things from a couple grams of marijuana. That's the kind of, I mean, essentially that's what happened, you guys. Whoever was detained, if they had some marijuana on them, well, they're either going to jail or they're getting cited or they're getting arrested or something like that, right?
Yes.
Okay. All right. That was the extent of your involvement in this case?
Yes.
Were you part of the FIT unit or the FIT team at that point? Okay. Everyone who was there, all of the law enforcement officers who were there were FIT team officers, right?
No.
No? They have just other regular beat officers who were called to the scene to assist?
There were canine officers there as well who are not part of the FIT team.
Got you. Because, of course, if you got some marijuana, or if you think that you're going to find some marijuana, you want to have the canine around to go ahead and kind of sniff around and find whatever's there. Is that about accurate?
Correct.
Okay. This was a marijuana buy operation. This wasn't some sort of gang operation, was it?
Correct. So,
okay. Thank you, McGavero.
correct. Thank you.
Thank you.
Did I tell you to get up? No, you didn't. Okay, go sit back down then, okay? Because there are higher considerations other than you. Ladies and gentlemen, I understand you want to take a comfort break, is that right? See? All right, okay, all right. Okay, so we're going to take a comfort break, ladies and gentlemen. Let's take, let's come back at 4 o'clock, okay? And then we'll start back at that time. Mr. Sharp, you can ask your questions then, sir. We're in recess, 15 minutes. All right.
Officer Applewhite,
Yes, sir.
are you looking for crime or targeting people?
Crime.
And why are you targeting high crime areas?
Because that's where most of our incidents occur, shootings, drugs, a lot of the, community members, they complain a lot. I'm speaking for Zone 4, and that's why we are in the area doing what we're doing.
And were you looking for weed for yourself?
No, sir.
Was this for purposes of targeting high crime areas?
Correct.
No further questions.
Anything further?
You weren't targeting on this day shootouts or killings or anything like that. You were targeting a weed sale, right?
Again, the detail was a Zone 3 detail. All I know it was to do is to go back some drugs, not necessarily weed, maybe crack, some pills, depend. But at that particular time, that's what I was going for.
Your assignment, your focus at that time, at that location on Cleveland Avenue, was to go buy some weed.
Some drugs, yes, sir.
All right, thank you.
Anything further? All right, at this point in time, may Officer Applewhite be permanently or temporarily excused as a witness?
Permanently.
All right, Officer Applewhite, thank you for your patience with us. I'm going to permanently excuse you as a witness. But don't discuss your testimony with anybody except the attorneys in this case, okay?
Yes, sir. Thank you.
So a couple of things there. First, it seems that one of the big points was that they're trying to suggest that this was just a simple drug deal. A guy was selling marijuana. It's not part of this massive criminal enterprise, a RICO conspiracy. So the more that the defense can try to show that what these individuals did or accused of doing is kind of isolated incidents, things that benefit them and not part of a criminal enterprise, that's going to help fight the RICO charge. Also, it seems they're trying to suggest that law enforcement was deliberately targeting these individuals. I mean, there's crime all over the area. Why are they focusing so much there? So those are two big points. That was the testimony of Officer Ian Applewhite with the Atlanta Police Department. And now we're actually going to do something different because the state's next witness is another Atlanta police officer, Jasmine Mangavero. We're going to turn into a testimony. Just want to give you a heads up. Some of these law enforcement experts, these witnesses, were not able to show what they appear, what we're not actually able to show them. That's based on the judge's ruling. It could change, we'll see. But due to security concerns, we're not actually able to show the faces of these witnesses. But let's go listen to more.
Please.
Yes, my first name is Jasmine, Jasmyn. Last name, formerly Hawkins, Hawkins. Currently Magavero, Mogavero.
And what name is your comment?
Magavero's fine.
Okay. I was asking which last name. Oh, okay. Also, Magavero, where are you currently employed?
City of Atlanta Police Department.
And how long have you been employed in the police department?
Since August of 2017.
And what is your current assignment?
The larceny from auto unit.
And how long have you been with that larceny unit?
From February of 2023.
If you can tell the jury briefly about your history with the Atlanta Police Department, starting with your assignment at the academy.
Okay. So I've been sworn since March of 2018. June, I was assigned to Zone 3 Morning Watch. I worked there until February of 2020. At that time, I was assigned to the Zone 3 Crime Suppression Unit. And then I stayed there until August of 2022. And then I went to Zone 3 Day Watch for a few months until coming here.
So it's safe to say a good majority of your career so far has been zone.
Correct.
And are you post-certified?
I am.
And were you post-certified in May of 2020?
Yes, I was.
I want to take you to May 9, 2020. What unit were you assigned with APD?
The Zone 3 Crime Suppression Unit.
And what were your job and responsibilities working with Zone 3 Crime Suppression Unit?
It's a proactive patrol unit, so conducting traffic stops, stops on suspicious persons in the community, or whatever other directive we had for that day. Usually proactive policing.
And you also said you served as a patrol officer within that unit.
Correct.
As a patrol officer and also working with the crime suppression unit, were you familiar with 151 Cleveland Avenue?
Correct, yes.
How are you familiar with 151 Cleveland Avenue?
I've answered a number of 911 calls there. I've completed traffic stops where people have pulled into that gas station, directed patrols, going inside speaking with the clerks at the gas station as well.
Why are there directed patrols at that location?
151 Cleveland Avenue, it's part of a, it's high crime at that location and in that general area.
And when we say high crime, what do we reference?
Shootings, drugs.
So a little bit more background information on her work, and we'll get into the meat of this. This is the testimony of Officer Jasmine Mangavero. This is all the Young Thug racketeering trial. We're going to hit a quick break, but here's the good news. We're actually going to pause the testimony. We're going to come right back. We don't want you to miss any moment of what's happening in that Atlanta courtroom, so stay with us here on Law & Crime. We'll be right back. back to Law and Crime, everybody. So today marks day 6 in the racketeering case against rapper Jeffery Williams, better known as Young Thug. Williams and 5 other co-defendants are on trial for charges including participation in a criminal street gang. And right now, we are watching the testimony of an Atlanta police officer. Now, before we jump back into the courtroom, I want to give you some perspective here. You're going to hear, and what we've been hearing so far a lot of, about these kind of what seem to be isolated drug deals involving the defendants, but they're part of the overall picture. The more the prosecution can show that these drug deals are actually to serve the overall gang, the criminal enterprise, that is how you get a RICO case. That's how you get a racketeering charge. Remember, it's the most serious charge, or arguably one of the most serious charges in the indictment. There is a murder charge, but the most serious, arguably, is RICO, because that's 5 to 20 years in prison. Let's go back and listen more.
I'm going to show you what's already been admitted as Case Exhibit 78J. It should show the screen. Excuse me, 79. And looking at 79J, where is 79J?
This is from the front of this gas station, 151 Cleveland Avenue Southwest.
And is that what you were just referencing as a high crime area?
Correct.
Now, when you go out to patrol or do target patrol, why are you going to that? What brings you to that area to target patrol?
Just due to the nature of crimes that happen at that gas station, at that intersection, Cleveland Avenue, Old Hapeville, supervisors and probably coming from the top down, they want to make sure those areas stay safe. So they ask us to spend some extra time there.
And in your experience, are you getting any calls from community members about that location on 161?
Yes.
Cleveland Avenue?
Yes, absolutely.
So in your experience, the community is concerned about what happens at there?
I sustain this to form.
In your experience, is the community concerned about what happens at that location?
Yes.
Same objection, Judge.
I'll sustain this to form. You can rephrase it.
Have you ever seen concerns about that location from the community?
Yes.
I hear Mr. Harvey mumbling in the background. If there's an objection, please state it. Okay, overruled, and your objection, Mr. Matthews, is overruled as well.
All right. I want to direct your attention to May 9th, 2020. Did you have the occasion to respond to 151 Cleveland Avenue?
Yes.
Okay. Why did you respond to that location?
We were in the location. There was an undercover officer at that location looking for drug activity at that gas station.
And do you recall what time of the day did you respond to that location?
So that would have been about 9:46 at night.
I see you open up an envelope. Is that your police report?
It is.
Okay. We're looking at a copy of your police report. Have a refresher memory as to what time you responded. I'm going to show you what it gives you.
So again, this is Officer Jasmine Mongavero talking about the crime in that area, talking about these undercover drug deals that are part of this Young Thug racketeering trial. Obviously, those kinds of photos showing the jury the scene is definitely going to help. We're going to take a quick break. When we come back, we want to see the continuation of Young Thug's trial. Stay with us here on Law and Crime. We'll be right back. And welcome back, everybody, to our live coverage here at Law and Crime. I'm Jesse Weber. Good to be back with all of you. So we remain focused on the racketeering case against rapper Jeffery Williams, better known as Young Thug. Williams and 5 other co-defendants are on trial for participation in a criminal street gang called Young Slime Life, or I should say that's what prosecutors say YSL stands for, because the defense claims that YSL is Young Stoner Life and it's just the name of Thug's record label. Now, while the state theorizes that YSL is actually a criminal enterprise responsible for all of this violent street crime, really interesting back and forth from the prosecution and the defense, but we want to get back into that Atlanta courtroom. And we are going to see the continuation of the testimony of Officer Jasmine Mangavero talking about an undercover operation. Let's go.
Permission to approach your honor?
You may.
I'm going to show you what's been marked as State's Exhibit 108R. Tell me if you recognize Exhibit 108R, and you can flip it.
I do, yes.
Okay, and how do you recognize Exhibit 108R?
This is the narrative portion of my incident report.
Okay. And we're looking at State's Exhibit 108R, help refresh your memory for the time you arrived at the location.
Yes.
Okay. You can go ahead and just read it to yourself, and once your memory refresh, you can look at it.
Okay. I'm all set.
Okay. What time did you go there?
At 9:46 p.m.
All right. And what happened once you arrived at the location?
We received word from the undercover officer at the location that he was just sold 1 gram of marijuana inside the gas station. And then at that time, he gave the description of a black male wearing jean jacket, white pants, white shoes, who sold him that marijuana.
Once you had that description, what did you want?
All of the units that were there that day pulled into the gas station. There were numerous other people at the gas station as well, but that was the main focus at first. And then when I approached, I got out of the vehicle. Other units had already got out of their vehicles and were in the process of detaining that male.
Okay, so let's slow down. You said there were a number of different locations going on in it. What do you mean?
So I can't give the exact number of officers that were there that day, but there were other vehicles that were associated with the vehicle that Mr. Beebe was in, and that they were seen interacting with him as well prior to our arrival.
Those other people you were seeing interacting with Mr. Beebe?
Correct.
All right. And what kind of car was Mr. Beebe?
He was in a white 2020 Honda Accord.
Now, were you all able to detain Mr. Beebe?
He was detained, correct.
Okay. Where was he seated when you all first interacted with Mr. Beebe?
He was in the passenger seat, front passenger seat.
And if you just said out high level, what kind of car was he in?
A white 2020 Honda Accord.
Okay. And once Mr. Beebe was detained, what happened next?
He was detained, and then at that point I started my search of the vehicle.
Okay. And what, if anything, was found when you did your search?
So there was 13 grams of marijuana in a clear baggie that was found inside the vehicle, the passenger seat, as well as a marked $20 bill that the undercover officer initially had, and that was used during that sale of that 1 gram of marijuana.
Before we summon our jurors, can I get a member from the defense and a member from the state to come on up?
You just said something like that.
Members of the media, before we call in our Officer Fikes at some point, is he going to be the next witness?
No, Your Honor, we have one witness before Officer Fikes.
Okay, are we going to get to Officer Fikes for today, you think?
It depends. I don't know. I guess we're almost finished with cross, and our next witness, Mr. Garcia, is not a long witness. So
Okay,
we could
all
get to him.
Members of the media, when we call Officer Fikes, given the issues that I told you earlier, not this next witness is fine, but with Officer Fikes, if you would not film him as well, okay? And I believe that the state is going to organize a meeting for all the councils for the respective media outlets to discuss with you next steps. So that's in the works and that's coming. But for the next witness, okay, Officer Fikes, please don't videotape him, okay? All right, thank you. All right. Can I call in the jurors, ladies and gentlemen? Okay, all right. Sergeant Ingram, is everybody ready?
Got a problem with this guy here again. What's the topic of the
Do we need to have a conversation with the bench? Lieutenant Walker, do we need to have a conversation with the gentleman at the bench here?
Yes, Your Honor.
Okay, councils, can you all be seated for me just a second? And I'll have a representative from the defense, please, come up. State, would you please come up?
Somewhere on the side.
Okay, it's talk radio.
That phone down. That phone down. Make sure that phone not recording.
No, just want to make sure. Okay, would you? Sorry, Mr. Burke. Is there an issue? Well, it seems to be an issue, and it seems that here, how you did it, I'm not sure. There's even Harvey Ray Slick, and he didn't speak it on, and I said this B-roll, and so that, trying to help it, there is an issue. But in terms of what you learned, that's a more constant. I just know that you're specific.
That was the one that was jiggling yesterday, Judge.
I don't want to be defensive every time I come in terms of Rule 22, is that what I can see?
Whoever's speaking, I can't hear you.
person at the school. So, you can take it.
But can you explain that to him? Because I don't know if I asked that.
Okay. You can take it still.
I was not recording. I had not started recording. I was setting up the tripod.
Okay, but we just want to make sure.
It seems to be an issue with her.
I have to communicate with you to welcome you. You have problems about your case, okay? Just make sure that when you're on the school about it, you can take it to work. That's fine, okay? But there shouldn't be any problem, okay? Thank you. Good? Okay,
Until the next situation.
thank you, sir.
You good?
Okay, all our jurors ready?
Yes, sir.
All right, okay. All right, thank you, Sergeant Ingram. Okay, summon our jurors, please.
All rise for the jury.
Let's see what Aaron can come up with. All right. Thank you, Sergeant Ingram. Ladies and gentlemen, please be seated. All right. Mr. Sharp, you ready? Yes, sir. Okay, come on up.
May it please the court. Good afternoon.
Good afternoon.
It's Investigator Magraville?
Magavaro.
Okay. All right, thank you. Couple questions. 151 Cleveland Avenue, this gas station, is that, are you familiar with that area, generally speaking?
Yes,
Okay, that is right across from where the McDonald's used to be on Cleveland Avenue.
correct.
All right. So, were you the lead, would you consider yourself the lead officer in this case?
Yes, they asked me to take the case.
Okay. And you're the one that wrote the report?
Correct.
Okay. And you were responsible for making charging decisions in this case?
It was a collective effort.
Okay. Were you one of the people consulted?
Yes.
And ultimately, you were in charge of documenting everything, correct?
Correct.
Did you take out the warrants as well?
It was a collective effort for that.
Okay. And I'm not going to ask you specifically about any laws, but generally speaking, as an officer, are you trained in criminal laws?
Yes.
Is that part of the training offered by Atlanta Police Department?
Yes.
And did you go through that training?
Yes.
Now, are you familiar generally with the criminal code of Georgia?
Yes.
Okay. All right. My understanding is Mr. Beebe is not the only individual that was arrested at 151 Cleveland Avenue that afternoon or evening.
Correct.
Okay. Also arrested was Chastity Williams, correct?
Correct.
Okay. For drugs.
Correct.
Shaquille Scott was also arrested.
Correct.
For drugs, including possession with intent to distribute drugs, correct?
Correct. Yes.
Okay. Antonio Johnson was also arrested for drugs.
Correct.
And I'm going to try with the pronunciation of this in Madam Court Reporter. It's, I believe it's Cyquavious. Sequavious Martin was also arrested at the scene, correct?
Correct.
For drugs?
Correct.
And a Curtis Barber, who was 35 years old at the time, correct? Which would make him 39 today, correct? Okay, he was also arrested for drugs, a firearm, and for possession with intent drugs.
Correct.
So you arrested, besides Mr. Beebe, 5 other individuals for drug offenses, 2 other individuals with possession with intent to distribute charges, correct?
Correct.
Okay. And that was based on your training that you received about the criminal laws of Georgia?
Yes, that's correct.
Okay. Now, in any of these individuals, in the arrests of Chastity Williams, Shaquille Scott, Antonio Johnson, Sanquavious Martin, or Curtis Barber, were any of those individuals, or Durante Beebe, were any of those individuals charged with Gang Act violations?
That I do not know.
Well, did you charge them with Gang Act violations?
I did not.
Okay. And those same 6 individuals, Durante Beebe, Chastity Williams, Shaquille Scott, Antonio Johnson, Sanquavious Martin, and Curtis Barber, do you see any of those individuals here today?
Can't see everybody, but no.
I have nothing further. Thank you.
Any further examination?
Yes, Your Honor.
Yes, Mr. Matthews Jr., go ahead, sir.
Hello, how are you?
So back in May 2020, at the 151 Cleveland, there were a number of officers who arrived to the scene, correct?
Correct.
And you did conjure a report in connection to your involvement in that case, correct?
Correct.
But in your report, you did not reference any video, graffiti, any photographs taken or any video that was taken of any gang graffiti at the premises of the 151 Cleveland, correct?
Correct. I did not.
And as a result of your involvement in that case, you didn't refer to any gang units? You didn't refer to any gang units in reference to your involvement within that case?
No, did not.
No further question.
Anybody else from the defense? Okay, any further redirect from the state?
Yes, Your Honor, briefly. As a Zone 3 officer with the prompt suppression unit, are you responsible for taking out gang warrants?
No, I am not.
Who's responsible for taking out any gang warrants?
Anybody who's on the gang unit.
I believe both Mr. Adams and Mr. Shard asked you about some of the other individuals found and some of the other items that were found at this scene during this evening. So we talked about Ms. Chastity Williams. She's the person who had was she the person in the car and had the book bag with marijuana?
Correct.
Sustained.
Ms. Shaquille Scott, what drugs were found with Ms. Scott?
Miss Scott had a pink purse on her person. Upon search of that purse, there was a total of 29 grams of marijuana located in a clear plastic bag. There were 15 smaller bags of marijuana as well. There were 2.2 grams of crack cocaine, 9.7 grams of MDMA located in 12 separate baggies, and 1.6 grams of powder cocaine along with $35 US.
And as it relates to the next individual, Mr. Antonio Johnson, what was found? What, if any, type of drug was found with Mr. Johnson?
Mr. Johnson admitted to having a blunt inside the car.
Hold on one second. I'm over the objection.
Going to Mr. Sinquavius Martin, what if any drugs did he have on?
3 grams of marijuana located in his right pants pocket.
And was Mr. Martin actually arrested, or was something else occurring?
He was given a copy of charges.
Okay. And let me go back as to Miss Chastity Williams. Was she arrested, or was she given something else?
She was given a copy of charges.
Okay, so not arrested.
Correct.
And Mr. Curtis Barber, what drugs did you find with Mr. Curtis Barber?
He had 34 grams of marijuana, as well as 8.9 grams of crack cocaine.
The marijuana, was it all in one bag or individual bags?
The marijuana was in individual bags, and then the crack cocaine was all in one bag.
Did Mr. Barber have cash?
He did.
How much cash did he have?
$2,000.
And did he have any weapons?
He did.
What kind of weapon did he have?
A black Keltec PLN.
I'm sorry.
Black Keltec PLN 30.
And were there any other weapons found? So we had the gun that was found on Mr. Beebe, this gun that's found on Mr. Barber. Were there any other weapons?
No. Not that I recall.
We'll take a look at your report, how professional.
No, those are the 2 firearms.
Okay. And all those were found at 151 Cleveland Avenue?
Correct.
And again, was that what you was told, or was called a high crime area?
Correct.
I have no further questions. Thank you.
Anything further?
Yes, please.
So it sounds like there were a host of people at that location who were either possessing drugs, right?
Correct.
Or possessing with the intent to distribute drugs, right? Or maybe even selling drugs, right?
Correct.
A lot of people, a lot of different people, right?
Correct.
Okay. You were asked a while ago whether or not you took out any, or you had the responsibility for taking out quote-unquote gang warrants. You heard that question, right?
Yes.
And you said no, that's not your responsibility.
Correct.
But someone else, if advised by you, and if you thought it was warranted, would have the ability to do so, right?
Not only if advised by me.
Okay? If advised by anyone, any law enforcement personnel who had any indication that there was some gang stuff or activity going on at the location that night, right?
Yes.
Okay, so this is May the 8th of 2020, right?
Correct.
Am I correct that in 2020, 2021, whatever, no one took out any gang warrants in regards to what happened at that location on May the 8th of 2020. No one took out any gang warrants, right?
I can't answer that question.
Did you?
I did not, no.
You advise anybody to?
No, I would not.
Are you aware of anybody taking out any gang warrants based on what happened at that location on that day that we're talking about?
No, I'm not aware of any.
All right. The last person that Madam Prosecutor asked you about, Barber, I think was his name. The guy who had some drugs and some money on him. What was he wearing? Describe his clothing to me if you don't mind.
I don't recall.
Okay. All right. Thank you, ma'am. That's all I have. Thank you, Judge.
Anybody else? Any further redirect, madam?
Just one quick question.
Sure, we'll see.
In addition to the $20 that Mr. Beebe had, was he found any other money? Mr. Beebe, in addition to the $20,
That the marked $20, did Mr. Beebe have any other money on him?
Yes.
Okay, how much?
$105.
All right, thank you.
All right, anything further? All right, at this point in time, Officer Maguire be permanently or temporarily excuse the witness.
permanently, Your Honor.
All right, madam, I'm going to permanently excuse you as a witness. Thank you for your patience with us this afternoon. Please don't discuss your testimony with anybody except the attorneys in this case, okay?
Okay, thank you.
All right, thank you, madam. All right, Ms. Hilton and any member of the defense, can I see you all for a second? All right, ladies and gentlemen, I have it on pretty good authority that the next witness is short. So, I know, please don't laugh openly, okay? All right. And the attorneys are hurt their feelings, okay? All right, so, I'd like to take up this one other witness and then recess for the day, and then we'll start afresh tomorrow morning, okay? So are we okay with taking one more witness? It's fairly short, okay? And then we'll recess for the day. All right. Call your next witness, madam.
It'll be Mr. Smith.
Your Honor,
All right, Mr. Smith, go ahead, sir.
State Clause Edwin Garcia.
All right, summon Edwin Garcia, please. All right, Mr. Garcia, good afternoon, sir. Come on up and approach the witness stand. Once you get there, before you sit down, if you'd be so kind to turn and face Sergeant Ingram, be sworn as a witness.
Yes, sir.
All right.
You swear affirm testimony you give the truth, the whole truth, nothing but the truth? I do. See? State spell your first and last name for the court to be now into that mic.
Perfect. My name is Edwin Garcia, first name spelled E-D-W-I-N, last name spelled G-A-R-C-I-A.
Good afternoon, Mr. Garcia.
Good afternoon.
Mr. Garcia, where are you employed?
I'm employed at the Georgia Bureau of Investigation, Division of Forensic Sciences in the Chemistry Section. This is also known as a state crime lab.
And how long have you been working at the GBI?
I've been working at the GBI for a little over a year now.
And can you tell the jury a little bit about your education and training?
Certainly. So I earned my Bachelor's of Science degree in chemistry from Morehouse College, and I underwent the Identification of Genus Cannabis training program at the GBI.
In that role, do you have any continuing education requirements?
Yes, I do. I have to fulfill hours of training throughout the year at the GBI, and I'm also still undergoing lectures that are oftentimes presented at the GBI.
And Mr. Garcia, have you personally had an occasion to chemically analyze leafy material?
Yes, I have.
How many times?
A little over 200.
And how many reports have you prepared in connection with your testimony?
Yes, a little over 200 as well.
Mr. Garcia, what is Delta-9 THC?
So Delta-9 THC, or Delta-9 tetrahydrocannabinol, it's a cannabinoid found in the plant material of the genus cannabis, and it is the main psychoactive ingredient in cannabis.
And how do you test for it?
So to test for Delta-9 THC in the plant material, I first collect a net weight of the evidence. A net weight is the weight of the evidence without any packaging. After this, I then conduct microscopy on the evidence, where I look at the smaller characteristic features of the plant material. After this, I then conduct gas chromatography mass spectrometry, abbreviated GCMS. Here, I'll prepare my sample, then I'll run it on the instrument. It'll go through the first part of the instrument known as the gas chromatographer. At this point, what the gas chromatographer will do will separate the sample that I prepared into the individual components that make it up. Once it exits the first part of the instrument, it'll then enter the mass spectrometer, the second part. Here what happens is that all those separated individual components will be fragmented. Those fragments will then be collected as data in the form of a graph known as a spectrum. I can then compare the spectrum of my sample data to that of a Delta-9 tetrahydrocannabinol reference spectrum to see if there are consistencies.
And if your test is performed accurately, what will those tests normally yield?
If the tests are performed accurately, the microscope will let me see the smaller features and will let me know if it is plant material of the genus cannabis, and the gas chromatographer mass spectrometer will let me know approximately how much Delta-9 THC is in the evidence submitted.
And is this type of drug testing that you describe subject to peer review?
Yes, this is subject to peer review.
And are there standards that control how these tests are performed?
Yes, there are standards. There are policies in place at the Georgia Bureau of Investigation.
And I want to back up just a little bit. You mentioned that they are subject to peer review. Who reviews?
So peer review means that, and for my cases, 100% of my cases are peer reviewed. This means that another scientist in the GBI crime lab reviews my cases to make sure there aren't any errors of any kind.
So going back forward to the standards, are there best practices as well?
Yes, there are best practices.
Okay. And is this type of testing generally accepted within the field of forensic testing?
Yes, this testing is generally accepted in the forensic field.
Okay. Your Honor, at this time, the State Lieutenant Mr. Garcia is an expert in cannabis identification.
Anybody wish to voir dire? Mr. Garcia? All right, hearing none, the court will designate Mr. Garcia as an expert in the area of forensic chemistry.
Thank you, Your Honor. In connection with Mr. Garcia, in connection with the deal as case number 2020-101-2426, did you test any leafy material in this case?
Yes, I did test leafy material in this case.
Okay. And Your Honor, permission to approve?
You may, sir.
Okay. Mr. Garcia, I'm showing you what's been pre-marked as State's Exhibit 93K. Do you recognize that?
Yes, I do.
And what is that?
This is the case, the report that I concluded to for the evidence that I tested.
Has that report, has there been any altercation, modifications to that report since you last authored it?
No, there hasn't been any.
Your Honor, at this time, the state will move to admit the state's proposed exhibit 93K.
Any objection to state's 93K? All right, hearing none, state's 93K is admitted and may be published as you see fit.
Thank you, Your Honor. So, Mr. Garcia, again, I'm sorry.
Yeah, no
What
worries.
did you test in this case?
So the items that I tested were 2 bags of leafy material. The item that was submitted was item 9. I tested sub-item 9A, 1 bag of leafy material, and item 10, which had 1 bag of leafy material, which I tested as well, making the 2 bags of leafy.
And did you use the principle that you just talked about when you performed the test in these cases?
Yes, I did.
And based on your testing, excuse me, were you able to reach a conclusion?
I was able to reach a conclusion.
And what was that conclusion, sir?
For item 9, sub-item 9A, my analysis confirms the presence of plant material of the genus cannabis with a greater than 0.3% tetrahydrocannabinol concentration. For item 10, my analysis confirms the presence of plant material of the genus cannabis and contains less than approximately 1% tetrahydrocannabinol.
No further questions at this time.
Cross. Mr. Adams.
So I see, do you still have that report up there?
Yes, sir, I do.
May I?
You may.
Thank you. All right. This is a report prepared by you in regards to the items that you tested, right?
Correct, yes.
And am I correct that you tested these items on, let's see, well, actually it was received by you on January 27th of 2023?
Is it fine if I look at the report?
Absolutely, please do.
Okay. Yes, January 27th, 2023.
Okay. So items that were seized back in May of 2020 didn't get to you until January 2023, this year.
I don't know when they were received, but I do know that I got them this year.
Okay. You don't know when the person who's, I'm sorry, let me see that quick.
Yes, sir.
All right. You would agree with me that this has a agency reference number and a case individual at the top listed, is that right?
Correct, yes. The report does have that.
The case subject, or the person listed is someone named Durante Beebe, right?
Yes, that's what it says on the report.
Okay. You don't know if and when that person, Durante Beebe, was charged with any sort of offense, but you know that you didn't test this item to determine what it was until January of this year, right?
Yes, I don't know when the subject was charged. I just know that I received this evidence this year, and this year is when I tested it.
All right. Mr. Garcia, thank you. That's all I have. Thank you.
Yes, sir.
Anybody else? All right, state have any redirect?
No.
All right. May Mr. Garcia be permanently or temporarily excused the witness?
Yes, Your Honor.
Permanent?
Permanent.
All right. Mr. Garcia, thank you for your patience with us. I'm going to permanently excuse you as a witness. You're free to go about your usual duties and avocation. Just don't discuss your testimony with anybody except the attorneys in this case, okay?
Yes, Your Honor.
All right, thank you, sir.
Thank you. Thank you.
All right, ladies and gentlemen, we're going to go ahead and recess for the day, as promised, because our next witness is going to take a little bit longer, so it makes sense just to start that witness tomorrow morning. Okay, so since we're concluding for the day, I'll give you the customary ad nauseam admonitions. All right, so. Are we going to talk about this case going into the parking lot or to how it is you're getting to your mode of transportation? No. All right. Are we going to talk about it tonight when we're home at the dinner table? No. We'll let people, third parties, come and talk to us about this? No. All right. What about phone a friend? No. How about look up something on the internet, or as my northern colleagues said, so you can become wicked smart about any of the other issues around that you've heard. All right, you're only going to hear what's in the four walls of this courtroom, right?
Yes, sir.
Okay, all right. Ladies and gentlemen, we appreciate your adhering to these ad nauseum admonitions. I know that people have told me they get tired of them, but remember, lawful trial, just trial, fair trial is to both sides. So we appreciate you adhering to all of these. Remember to leave your notepads in the basket, take a juror sticker, and so you can be prepared to come in tomorrow morning. Remember tomorrow morning, I'd like you all to be here for 9:30 for an anticipated 10 o'clock start time, and we'll go ahead and see where the day leads us at that point. I believe that tomorrow, we're going to probably leave around 4 o'clock. All right, so we'll get a full workday in. We will probably come recess around 4, and then remember Thursday and Friday will be augmented days to allow you all to have some, make other plans and appointments, okay?
Yes, sir.
All right, any questions of me, ministerial in nature? Anyone? Okay. How's your headquarters back there?
Wonderful.
Good? Any problems, any issues?
Working through it.
Okay, all right, well, you know, I've been providing an ad nauseum supply of snacks, okay, so you got to bring your own food, all right? But it's the only thing I can tell you, okay?
Long shot, but
say again?
I know it's like a long shot, but can we get like lunch maybe once every 2 weeks or so? I mean,
You got a lot of nerve, man. I'm trying to ask me for lunch?
that's why you could be part of the jury.
For you to ask those questions? Okay, all right. No, we don't provide lunches. The county's got bad credit, so we used to be able to. We used to be able to provide lunches because I had a juror account. I don't at this point in time, and it's one of those things that I wish I could provide you at this point in time, but I'm not in a position to do so. I can tell you that once you become a deliberating jury, that we might be able to make some arrangements for some substance. Okay. All right, but not till then. You got to bring your own stuff. All right. Okay. Huh? Okay, well, you know, we have plenty of grocery stores, and I know it's winter, you know, but anyways, bring, like I said, ladies and gentlemen, you're welcome to bring whatever you like. I know that we provided you some small snacks, and I'll continue to do that as we can, okay? But you're welcome to bring anything as you like. Remember, the only caveat I told you is as long as you clean up after yourselves, you're welcome to bring anything you want, okay? Except alcohol, remember? Okay, all right. Okay, anything else from anybody? Okay. All right. Ladies and gentlemen, thank you for your patience you've given us and continue to give us and will continue to give us in the trial of this matter. And unless you have any other inquiry or comment from me, I'll go ahead and excuse you, and we'll see you tomorrow morning for 9:30 for an anticipated 10 o'clock start time, okay?
Yes, sir.
Okay, all right. Ladies and gentlemen, we're in recess. All right, all rise. Okay, ladies and gentlemen, please be seated. Our jury has left us. Okay, any minister inquiry of me, counsels? Okay, before we recess, when we do recess, Mr. Harvey, can I talk with you about an unrelated ancillary matter? And I do want to just kind of put this on your radar. You know, I get a lot of inquiry from people in regards to just everything that goes on, but one of the inquiries I have is in regards to being able to hear everybody, okay? And I would just tell you all, and I think Ms. Weaver has basically reinforced this ask of you, and because she's responsible for taking down the verbatim record, if you could please, for those of you who are not using the microphone, do that, because it produces better audio in terms of just being able to be heard, as well as for Ms. Weaver to hear everything to take up the record. So some of you speak very loudly as a matter of course. It's not an issue being heard, but some of you could work on just the timbre and loudness so that everybody can hear you, in particular, Ms. Weaver, okay? All right, so, Mr. Adams, I don't think you had that problem, okay? You're good, all right? But no, just that it's been mentioned to me that some of you cannot be heard. So please just work on that, and that's all I'd ask, okay? All right, anything else from me? All right, so I'll see everybody tomorrow morning for 9:30, and we'll get started between 9:30 and 10 o'clock tomorrow morning, okay? All right, unless there's anything else, we're in recess. All right, see you tomorrow.